Εντάξει, ναι. Δουλεύει. Αρχίσουμε. Δουλεύει. Λοιπόν, ναι, στο μικρόφωνο. Λοιπόν, καλημέρα. Ας αρχίσουμε. Από τη μεριά του οργανισμού αν θέλετε, μεταφραστικά είναι έξω όποιος θέλει μηχάνημα το ειδικό. Από τη μεριά λοιπόν του Οργανισμού Μεσολάβησης και Διαιτησίας, σας καλωσορίζουμε. Είναι μια εκδήλωση η οποία γίνεται μετά από πολλά χρόνια. Όπως ξέρετε, ο Οργανισμός Μεσολάβησης και Διαιτησίας έχει σαν καθήκον αμφιβολητεία να μεσολαβεί μεταξύ εργοδοτών και εργαζομένων για την επίλυση συλλογικών διαφορών. Έχουμε τις τρεις διαδικασίες γνωστές: συμφιλίωση, μεσολάβηση και διαιτησία. Επίσης, θα πρέπει να τονίσουμε ότι είναι ένας από τους λίγους οργανισμούς στην Ελλάδα ο οποίος δεν είναι δημόσιος με την κλασική του όρου έννοια, αλλά διοικείται από τους ενδιαφερόμενους άμεσα, δηλαδή από τους εκπροσώπους των εργοδοτών και εργαζομένων. Επίσης, είναι ένας οργανισμός που λόγω της ευαισθησίας του καθορίζεται από την αρχή της ομοφωνίας. Με την αρχή αυτή της ομοφωνίας και των 11 μελών του Διοικητικού Συμβουλίου επιλέγονται και οι μεσολαβητές και οι διαιτητές. Άρα, όπως αντιλαμβάνεστε, το στοιχείο της σύμπνοιας και της εξέβρεσης συμβασμών είναι αυτό που χαρακτηρίζει τον οργανισμό. 30 χρόνια. Ο Οργανισμός Μεσολάβησης και Διαιτησίας έχει ξεκινήσει από το 90, 91, 92 άρχισε την πλήρη λειτουργία του, άρα είμαστε στα 30 χρόνια. Θα μπορούσε να πει κανείς πολλά για αυτό τον οργανισμό. Εγώ ήμουν από την αρχή, τον κύριο Κουκιάδη επίσης από τα πρώτα χρόνια. Μπορεί να πει και πολλά καλά, μπορεί να έχει και να διαπιστώνει και κάποιες σοβαρές αδυναμίες ενδεχομένως, ανάλογα από την πορεία. Αλλά ένα δεν μπορεί να αντιθεί κανείς, ότι έχει καθορίσει σε σημαντικό βαθμό την πορεία των εργασιακών σχέσεων στη χώρα μας και νομίζω ότι θα συνεχίσει και στο μέλλον έτσι όπως διαφαίνεται τώρα με νέες αρμοδιότητες που έχει. Ας έρθουμε στο σημερινό τώρα. Γιατί σήμερα, 30 χρόνια βεβαίως, και γιατί Θεσσαλονίκη. Θυμάμαι πριν 15-16 περίπου χρόνια, το 2005, μια αντίστοιχη εκδήλωση είχε γίνει εδώ για τα Βαλκάνια, για τη Συλλογική Διαπραγμάτευση στα Βαλκάνια. Μια αντίστοιχη εκδήλωση διοργανώνουμε και σήμερα. Γιατί πιστεύουμε ότι οι γειτονικοί λαοί των Βαλκανίων έχουν πολλά να πούν μεταξύ τους, πολλά κοινά, πολλές διαφορές. Άρα λοιπόν αξίζει να υπάρχει μια περιφερειακή συνεργασία και μια περιφερειακή συνεννόηση στο επίπεδο των Βαλκανίων. Και γιατί Θεσσαλονίκη? Θεσσαλονίκη γιατί πιστεύουμε, επειδή την αγαπάμε τη Θεσσαλονίκη βέβαια, αλλά γιατί πιστεύουμε ότι είναι ένας από τους κόμβους των Βαλκανίων, είναι πιο κοντά σε σχέση με την Αθήνα, σε αυτό που λέμε Βαλκάνια, αυτή την περιοχή όλη. Άρα λοιπόν, πέρα από την κλασική φιλοξενία της πόλης, η οποία είναι δεδομένη, υπάρχει και ένας ευρύτερος λόγος για να γίνει αυτή η εκδήλωση εδώ στη Θεσσαλονίκη. Επίσης, θα πρέπει να επισημάνω, να ευχαριστήσω από την δική μου τη μεριά όλους όσους βοήθησαν σε αυτή την εκδήλωση, η οποία μεταδίδεται και διαδικτυακά, σε ένα ευρύτερο περιβάλλον, γιατί έγινε με δυσκολίες, έγινε με σύνεση, λόγω της πανδημίας ακριβώς, και κατά συνέπεια βοήθησαν πολύ σε αυτό. Βοήθησε πολύ το Αριστοτέλειο Πανεπιστήμιο Θεσσαλονίκης. Ο καθηγητής ο Άγγελος του Σεργίου ήταν ο σύνδεσμός μας σε αυτή την συνδιοργάνωση. Τον ευχαριστούμε λοιπόν και όλο το Αριστοτέλειο. Τον κύριο Γκλαβίνη, τον κοσμήτορα, ο οποίος βοήθησε επίσης ακόμα και στο να έχουμε αυτή την αίθουσα. Πρέπει να ευχαριστήσουμε επίσης τους εισηγητές, οι οποίοι μετακινήθηκαν σε αυτή την δύσκολη περίοδο από τις χώρες τους, διαθέτοντας τον πολύτιμο χρόνο τους και για τη μετάβαση, αλλά και για να προετοιμάσουν την εισήγηση. Είναι θετική ιδιαίτερα η συμβολή τους. Και επίσης τους προέδρους που ανέλαβαν τις προεδρίες των σημερινών συνεδριών, Τους ευχαριστούμε και αυτούς και βέβαια όλους εσάς οι οποίοι είστε μαζί μας για να ολοκληρωθεί με επιτυχία αυτή, ελπίζουμε, αυτή η εκδήλωση. Καλή επιτυχία λοιπόν στη σημερινή συζήτηση. Σας ευχαριστούμε πολύ. Καλώς ήρθατε. Να είστε καλά.
Νομίζω, καλημέρα σε όλους, σε όλες και σε όλους. Με ακούτε? Good morning to all of you. Είμαστε στο πρώτο τραπέζι σήμερα του συνεδρίου του ΟΜΕΔ με θέμα τις σύγχρονες τάσεις της Συλλογικής Διαπραγμάτευσης στα Βαλκάνια και στην Νότια Ανατολική Ευρώπη. Επιτρέψτε μου καταρχάς να ευχαριστήσω τον Πρόεδρο, τον οικοδεσπότη εδώ, αν και Αθηναίο στη Θεσσαλονίκη, για την τιμή που μας κάνει να οργανώσει στην πόλη μας και να με αναθέσει και την Προεδρία της πρώτης συνεδρίασης. Θα ήθελα να πω και ορισμένα λόγια έτσι πολύ εισαγωγικά, να δικαιολογήσω την παρουσία μου εδώ πέρα. Και νομίζω ότι το συνέδριο αυτό πολλοί το έχουν φανταστεί να το οργανώσουν, δεν το έχουν οργανώσει μέχρι τώρα. Νομίζω ότι το έκανε ο καθηγητής, ο κύριος Παπαδημητρίου, και θα έλεγα ότι το τελικό πόρισμα του συνεδρίου είναι προδιαγεγραμμένο. Νομίζω δηλαδή θα καταλήξουμε όλοι από όλες τις χώρες της Βαλκανικής και της Νοτιοανατολικής Ευρώπης στο ίδιο συμπέρασμα, όπως φαντάζομαι και σε όλη την Ευρώπη. Η εξισορρόπηση της εξουσίας μεταξύ των εργαζομένων και των εργοδοτών οδηγεί στην οικονομική ανάπτυξη και την κοινωνική ειρήνη. Δηλαδή, πίσω απ' όλα είναι ο διάλογος, η συνένεση. Ο διάλογος αφορά τους πάντες, από τη γυναίκα μας, τον γείτονά μας, τον συμπολίτη μας και η παγκόσμια ειρήνη που τώρα κινδυνεύει και φυσικά η εργασιακή ειρήνη που είναι το θέμα του συνεδρίου. Φυσικά, η οποιαδήποτε ισορροπία είναι εύθραυστη, δεν είναι εύκολη, που σημαίνει ότι ανά πάσα στιγμή αναζητούμε νέες ισορροπίες. Και έρχομαι τώρα στη δεύτερη, αυτά είναι χιλιοϊπωμένα, αποδεκτά από όλους. Έρχομαι στο δεύτερο σημείο του συνεδρίου, του σημερινού συνεδρίου, που είναι η συλλογική διαπραγμάτευση στις χώρες της Βαλκανικής και της Νοτιοανατολικής Ευρώπης. Και νομίζω ότι εδώ, αν μπορούσε κάποιος να πει κάτι, είναι ότι γιατί επικεντρωνόμαστε στον χώρο αυτό, γεωγραφικό, γιατί αναζητούμε κάποια κοινά σημεία, κάποιες κοινές πορείες, κάποιες κοινές εμπειρίες, ίσως και σημεία διαφοροποίησης, γιατί διδασκόμαστε όχι μόνο σε αυτά που συμφωνούμε, αλλά και αυτά που διαφωνούμε. Και έτσι λίγο να κάνω τη συζήτηση πιο... Γιατί τι είναι Βαλκάνια τελικά, η Νοτιοανατολική Ευρώπη, αυτό δεν θα το λύσουμε σήμερα και κανένας δεν θα μπορούσε να το λύσει. Το μόνο που θα μπορούσα να πω στο σημείο αυτό, και έτσι λίγο να διευρύνω και τη συζήτηση, το σημερινό συνέδριο μου θυμίσε την ταινία του Θόδωρου Αγγελόπουλου, το βλέμμα του Οδυσσέα, που είναι μια περιπλάνηση στη Βαλκανική και η αναζήτηση των κοινών τόπων αυτών, ακόμα και η Βαλκανική είχε και η μετακίνηση των εργαζομένων, πάρα πολλών εργαζομένων μέσα στη Βαλκανική περιοχή. Και νομίζω ότι αν κάτι που χαρακτηρίζει τις κοινωνίες μας, άρα έχει σημασία το πώς γίνεται αντιληπτή η συλλογική διαπραγμάτευση, και θα μου το πούνε οι ομιλητές, θα βγει από τους ομιλητές, ότι κατά βάθος είμαστε συγκρουσιακές κοινωνίες. Η συνένεση είναι πάρα πολύ δύσκολη. Έχουμε εδώ λίγο αυθαιρετό, ένα πρόσημο βίας στα Βαλκάνια, αλλά γι' αυτό είναι ακριβώς η συλλογική διαπραγμάτευση, να τα ξεπεράσουμε όλα αυτά και να λύσουμε όλα τα θέματά μας, από την εργασία ως όλα τα άλλα, με το διάλογο. Νομίζω ότι το συνέδριο θα είναι πάρα πολύ διδακτικό, γιατί θα μας φέρει ακόμα πιο κοντά και καλό, νομίζω αρκετά είπα, καλό να λάβει το λόγο ο καθηγητής, ο ομότιμος καθηγητής Κώστας Παπαδημητρίου, γνωστός σε όλους. Συνήθως το χρέος του Προέδρου είναι να παραθέσει ένα εκτενές βιογραφικό, να πει με τι έχει ασχοληθεί, ο ομιλητής, που έχει συμμετάσχει, όλο αυτό το παλμαρές που λένε οι Γάλλοι. Εγώ δεν θα μείνω σε αυτά που έχει κάνει ο αγαπητός φίλος ο Κώστας Δημητρίου, θα κάνω κάτι που δεν κάνουν οι πρόεδροι, θα αναφερθώ και ας μου το επιτραπεί στις ιδιότητες του ομιλητή. Δηλαδή, τι είναι αυτό που πίσω από όλα αυτά που έχει κάνει. Θα έλεγα ότι ο Κώστας Δημητρίου είναι ένας πολυπράγμων επιστήμονας, γνωστός στον χώρο του, μιλίχιος, πολύ δραστήριος. Όσοι έχουμε συνεργαστεί μαζί του, έχουμε τις καλύτερες εντυπώσεις. Και εν τέλει θα έλεγα ότι είναι ένας δρομέας όχι ταχύτητας, όχι ημιαντοχής που λέγαν παλιά στίπλο, αλλά μεγάλων αποστάσεων. Και το αποδεικνύει ότι ακόμα και ο Σωμότυπος έχει ένα νεανικό σφρίγος, επιστημονικό, και νομίζω σήμερα θα το αποδείξει έμπρακτα με αυτό εδώ θα έλεγα, όχι απλώς εισήγηση, γιατί έχουμε εδώ και τον καθηγητή μας, τον κύριο Κουκιάδη, τι να πω εδώ πέρα. Όχι Πριτάν, είναι λίγο. Θα έλεγα, εγώ θα έλεγα ο εμπνευστής και αυτός που υλοποίησε τον καλύτερο νόμο στην Ελλάδα. Που αυτό πράγμα δεν έχει ξαναγίνει. Στην Ελλάδα οι όλοι νόμοι είναι αντικείμενο αντίπαλων αντιπαλότητας κλπ. Επομένως, καλώ τον καθηγητή Κώστα Δημητρίου να λάβει το λόγο. Αν θέλετε να έρθει και ο καθηγητής κύριος Γιασάρεβιτς, please take place here, και ο επόμενος ομιλητής μας, ο κύριος Νίκος Τριμικλινιώτης.
Λοιπόν, επανέρχομαι τώρα με άλλη ιδιότητα. Συγχωρήστε με που θα μιλήσω στα αγγλικά, αλλά για λόγους ενότητας των ομιλιών δεν θα χρησιμοποιήσω τη μητρική μου γλώσσα. The structure of the Greek economy is marked by some historical trends at the beginning. The structure of the Greek economy is marked by very few large companies and many micro and small firms. The wider part of the Greek economy concerns services, a relatively small part concerns industry, and a disproportionately small part concerns agriculture. There is a problem also of long-term structural unemployment, with a relatively high number of unemployed for a long period, as well as high youth unemployment. Also, there is a long tradition of trade union participation. The first legislation concerning trade unions dates back to the beginning of the 20th century. Unionization rates are actually high in the public sector, around 60%, but very low in the private sector, only 18%. The recent financial crisis and the rise of unemployment affected also negatively the unionization rate. The Greek trade union movement is in favor of the trade union unity. Therefore, there are only two confederations, one for employees and one for civil servants. Even if freedom of association allows the creation of several trade union organizations at the same level, the workers, even of different tendencies, prefer to join the same trade union organization. In return, the law provides, in order to promote this unity, that the board of directors of all trade unions organization must be composed of representatives of all tendencies so that all parties can express their ideas. Employees' participation in the company through representatives elected by all employees, even it is provided by law, doesn't play any important role. Employees prefer to be represented by the trade unions rather than the work councils, which even does not exist. And now the rules, the legislation. Collective autonomy is a fundamental principle of Greek law recognized at constitutional level. Reasons related to the protection of the general interest may lead to certain restrictions of this fundamental freedom. Greek courts have been called upon several times to evaluate the constitutionality of such restrictive measures. Greek courts are rather hesitant to review legislative activity involving limitation on collective autonomy, and sometimes this is understandable. Also, Greece has a tradition of legislative regulation of the regime of collective agreements. The legislator provides in detail for the persons whose employment relationship are likely to be regulated by collective agreements, the content and duration, the senior parties, the force and scope of application of collective agreements, as well as the level of bargaining, all that in details. On the contrary to other countries like Italy, where sometimes there's no legislation. That means it's the complete freedom of the parties. But in Greece, everything is regulated. And let's see what's happening in particular. The application of collective agreements. The application of collective agreements concerns dependent employment relationships. The law of 1990 takes into account, however, the reality of economically dependent workers. Economically dependent. Collective agreements can also regulate the relations of persons who, although non-bound by dependent employment relationship, provide their work under conditions of economic dependence, and they need protection equivalent to that of employees. However, this innovative standard for Greek labor law has had no practical application. After more than 30 years, 25 years in the implementation of this provision, no collective agreement has extended its scope of application to economically dependent workers. Therefore, it's a rule in theory, not in practice. However, this principle is recently confirmed in 2021. A new law provides that platform workers, irrespectively from the nature of their contract, may create trade unions, negotiate in order to conclude collective agreements, and exercise the right to strike. Therefore, perhaps we have a new step take into account the new reality of platform workers. The principle of favor. The most favorable arrangement clause has been introduced since 1990. In case of conflict between collective agreements of different levels, the agreement or clause providing for most favorable conditions for the employees would apply. This principle was affected during the period of crisis. The company agreement prevailed over the branch level agreement, even if it contained less favorable working labor conditions than the latter. The principle of favor has been restored in 2018. From 2018 onwards, company agreements may provide only more favorable conditions than the branch agreements. Otherwise, the less favorable terms don't apply. However, a new exception is provided. Local branch and local professional agreements pervade the national ones and may provide less favorable conditions. This new exception. Thus, a new factor of eventual instability is introduced. Let's know the level. of bargaining. The Greek bargaining system combines all levels of collective agreements. Bargaining takes place at national, branch, occupational, or professional, and company levels. There is thus different categories of collective agreements corresponding to the respective levels. National collective agreement, branch collective agreement, occupational collective agreement, and company collective agreement. The Greek system of industrial relations in the pre-crisis period was centered on the concept on multi-level bargaining. This being complemented by the operation of extension mechanism and the favorability principle. This system was differentiated after 2012 due to important legislative changes due to the crisis. At sectoral and occupational level, the changes in the legal framework in conjunction with the deepening of the crisis resulted in the near collapse of collective bargaining. Let's see first in detail the national level. The contractual parties to the national interprofessional collective agreement have traditionally included the 5 employer associations and the Greek General Confederation of Labor, GSE. The function of the national interprofessional agreement was traditionally to ensure a minimum wage safety net at national level, including unskilled workers who were not covered by branch or other collective agreements. The minimum wage and minimum working conditions stipulated under the national agreement were applicable to all workers under a private law employment contract through the country, regardless of whether they were members of a trade union. The negotiation of minimum salary might continue to take place at the level of this system have been changed. The negotiation stays actually at the national level, but not in the same quality. First, because the minimum national salary actually is provided only by law. Certainly, the negotiation in the same framework at national level is possible, but since the enactment of the legislative minimum wage, no general collective agreement includes clauses on wage issues, although that would be possible. Therefore, we have at national level only the legislation rules, and even it's possible to conclude contractual more favorable clauses. This is not done. The party at national level simply repeat in the new collective national agreement the existing clauses without adding new ones. Therefore, although the parties maintain good relation at this level, they practically fail to enrich the collective agreements. The branch, the sector. Branch or professional collective agreements may set wage levels and provide other terms and conditions designated to address the specificities of the branch. The most obvious development of the last decade has been the drop in the overall volume of bargaining at the branch level, as the parties found it difficult to reach agreement in the absence of appropriate legal institutional incentives as prevailed before 2011. Instead of around 100 branch agreements and 40 occupational level agreements which have been concluded prior to 2011, actually less than 19 branch agreements per year and less than 6 occupational level agreements were concluded during the period 2012 2012 and 2021. And more specifically, 15 national branch agreements were concluded in 2018, 10 in 2019, 7 in 2020, and 12 in 2021, and 6 national professional agreements in 2018, 5 in 2019, 1 in 2020, and 5 in 2021. You see, the comparison is critical, much less collective agreements actually. And the company level. Company agreements can be concluded irrespectively from the size of the company, whereas before the crisis legislation said agreements could only be concluded to companies employing more than 50 employees. The centralization of collective agreement was encouraged through various pieces of legislation introduced from 2010 onwards. It was linked to the abolition of the favorability principle and the provision of scope for company-level derogations via legislation during the crisis. The contraction in branch and occupational bargaining was accompanied by an increase of company-level agreements. In contrast with the pre-crisis landscape of bargaining, company-level agreements were the predominant form of collective bargaining. The highest rate of company-level agreement was reported in 2012, more than 900 agreements, in contrast to 170 in 2011. The reset of the favorable principle in 2018 modifies once more the landscape. The number of company agreements is decreasing since then. Only 1,093 were concluded in 2019, 1,050 in 2020, and 1,080 in 2021. You see, we have a decrease, we have an increase, and now we have a decrease. The issues. Collective agreements are certainly an important source of labor law. They may regulate almost all matters which concern employers and employees. Apparently, agreements on wage is the most important issue of collective agreements. Until 2013, I've said it, the determination of minimum wages at the national level fell within the exclusive competence of collective agreements. From this year onwards, the national minimum wage can only be set by the legislator, even if the social partners still have the power to provide for a higher wage level for their members. Working arrangements, leaves, health and safety of employees constitute frequent bargaining issues. As the introduction of new technologies plays an increasingly important role in our companies, the issues of protection of employment, working condition of these new workers, training and teleworking often constitute a bargaining issue. However, COVID issues have not been included in recent collective agreements, even if they directly affect the functioning of the employment relationship. The role of state institutions still remain here the main factor. And the coverage for collective agreements. As the participation of employees in the trade unions is declining, the balance of power between employers and employees is seriously altered. The number of collective agreements, we have seen that, has recently been decreased. In practice, during the pre-crisis period, the system was relatively stable in terms of structure, coverage, and operation. And during the period, the structure is been changing. I'm not going to repeat here the numbers, but there is a lack actually of coverage concerning particularly the branch agreements. This decrease is firstly due to the decline of participation of employees in trade unions. Secondly, the limitation of possibility of unilateral recourse to arbitration in the event of failure of bargaining results in the decrease of the number of collective agreements and of arbitration awards. Changes in the arbitration system, for instance, removing the unilateral right of recourse to arbitration, led to a sharp decline of arbitration decisions, as in the pre-crisis period, negotiation used to take place under the pressure of arbitration. Collective agreements continue to play an important role only in larger companies, banks, and companies in the private sector. In other companies, the role is not, it appears not so important. And finally, the settlement of labor disputes. The establishment of collective labor dispute settlement has for decades been an important component of Greek industrial relations system. The Greek legislature founded the ΟΜΕΔ, the Mediation and Arbitration Organization, whose task was the establishment of the mechanism of settlement of collective labor disputes. It is managed jointly by the employers and employees, which provide conciliation, mediation, and arbitration. Its board of directors has no connection with the state apparatus. Employers and workers organizations equally participating have a primary responsibility for running the organization. The choice of mediation is done in a way that ensures the objectivity and their ability to perform very highly sensitive work. And the settlement of collective labor disputes in Greece remains an issue that generates doctrinal debate, jurisprudential disputes, and social tension. Each of these procedures provided by the law have a different function, even if the task performed by the third person who intervenes to settle the dispute can be overlapping. First, the conciliation. Conciliation is the first stage of the collective labor dispute procedure. It's the method by a third party tries to facilitate the contact between the parties with a view to reaching an agreement. Conciliation may concern all types of collective labor disputes arising between employers and employees. And after the recent change of the legislation, the conciliation is entrusted to ΟΜΕΔ, even in the past was entrusted to the Labor Inspectorate. Even the conciliation actually, some months before, is entrusted to ΟΜΕΔ. The request for the conciliation's intervention might come either from the competent trade unions, on the one hand, or the employers' organization, or the employer in case of company labor disputes. The new competence seems actually to be one of the organization's main responsibility, taking into account the number of mediation and arbitration requests has been decreased. The mediation, if the parties cannot reach an agreement during negotiation or during conciliation, mediation is possible only in order to conclude a collective agreement. The mediator is chosen by a specialist, either by a common agreement, or by lot if they're not able to reach an agreement. This particular, that at the end of the procedure, the parties to the dispute are free to accept or to reject the mediator recommendation, since it does not create any rights or obligation for the parties. And finally, the arbitration. The system of collective agreement, dispute settlement, and more particular arbitration has marked the Greek collective industrial relation for a long period. The process of settling collective labor disputes following a recourse to arbitration has characterized Greek collective relations over the past 20 years, often providing a solution to several serious labor disputes. And this system has been finally abandoned in 2012. Subsequently, it was the Greek Council of State that ruled in 2014 that unilateral recourse arbitration was in compliance with the principle of collective autonomy, and the freedom of bargaining, and also, quite paradoxically, that the Greek constitution requires the legislator to establish an arbitration system providing the unilateral recourse. Finally, the legislator, complying with this decision, has introduced such an arbitration system. However, this system is also attempted to limit the power of arbitration in multiple ways. Firstly, by providing arbitration committees instead of single arbitration. And secondly, by providing a second level of arbitration where arbitration committees are composed mainly of judges. And thirdly, by providing for extending judicial review of the reasoning of arbitration awards. Finally, recourse arbitration can take place firstly by common agreement between the parties. The law provides for 2 cases of unilateral recourse arbitration, only in the context of essential services and only in the context of disputes concerning the general interest. Therefore, unilateral recourse arbitration is considered an exceptional step either in the case of refusal by one of the parties to participate in dialogue, a bargaining, or in the case of rejection of the mediator's proposal. The arbitration award has the force of collective agreement. All provisions relating to collective agreements apply by analogy to arbitration awards. This system functions until today, but in a less decisive way than in the past. Less arbitration awards are currently being used. Only 5 arbitration awards of first degree were issued in 2019, 5 in 2020, and 1 in 2021. Therefore, to conclude, I think the ΟΜΕΔ actually is at an intermediate stage. That means there is a new procedure, the conciliation, which is introduced. There is less recourse to arbitration and mediator. So we have to wait to see the conclusion. Anyway, I think that even during this stage, the ΟΜΕΔ is going to continue to play an important role concerning the evolution of the Greek relation system and the bargaining procedure. Thank you very much for your attention.
Ευχαριστούμε τον ομότιμο καθηγητή κύριο Παπαδημητρίου για την πληρέστατη εισήγησή του. Νομίζω μας εξέθεσε, ανέλυσε όλο το θεσμικό πλαίσιο στην Ελλάδα. Ένα ερώτημα που φυσικά που πλανάται γενικά σε όλους εμάς που είμαστε εδώ πέρα είναι αν φυσικά η νομοθεσία θέτει τους κανόνες παιχνιδιού. Αλλά χρειάζεται παιχνίδι όμως. Και πάντα η ερώτησή μου θα ήταν αν θα είχαμε ποδόσφαιρο χωρίς τους κανόνες του ποδοσφαίρου. Πιστεύω ότι σίγουρα η νομοθεσία δεν είναι ένας απλός αρρωγός, είναι και καταλύτης. Δηλαδή μπορεί να προκαλέσει εφόσον το θέλουν τα μέρη, εφόσον το θέλουν οι παίκτες. Και αυτό είναι η προσπάθεια του νομοθέτη να ακολουθήσει, να προκαλέσει, ένα είδος αντανάκλασης της πραγματικότητας. Και το έχουμε δει και στην Ελλάδα με την κρίση δημοσίου χρέους το 2012, που άλλαξε ο νόμος, ακολούθησε κάποια άλλα. Δυστυχώς η νομοθεσία θα πρέπει να προσαρμοστεί πλέον. Η κρίση του δημοσίου χρέους πέρασε και περνάμε σε μια νέα φάση που είναι διαδοχικών κρίσεων πλέον. Η μία τελειώνει, η άλλη αρχίζει. Και δεν ξέρω η συλλογική διαπραγμάτευση σε στη νέα παγκόσμια πραγματικότητα και βαλκανική πραγματικότητα πώς θα κάτσει. Τώρα είναι η σειρά του καθηγητή του Σενάτ Γιαζάρεβιτς να μας φωτίσει για την Σερβία, τι γίνεται εκεί πέρα. Είναι τόσο εκτενές το βιογραφικό του καθηγητή που δεν απομονώνω κάποιες ιδιότητές του. Είναι καθηγητής, κρατάω το Novi Sad, Έχει συμμετάσχει από ό,τι βλέπω σε όλες τις επιτροπές, σε όλα τα θέματα που απασχολούν τη γείτονα χώρα και τον παρακαλούμε να κάνει την εισήγησή του. Dear Professor, the floor is yours. Okay.
Before my presentation starts, dear Madam and Sir, it is great honor and pleasure to be here in Thessaloniki. I would like to congratulate ΟΜΕΔ 30 years of successful work, and I also send greetings from our agency for dispute settlement. They also congratulate and would like to make a cooperation with ΟΜΕΔ. I hope we will realize that. Thank you. I will follow the professor's questions about collective bargaining and try to speak in brief about Serbian collective bargaining system. I see a lot of similarities and a lot of differences because our economies are not the same. I would like to stress some typical and some untypical trends or situation. First of all, collective bargaining was introduced in Serbia, which was part of ex-Yugoslavia between two world wars. We had a typical European, I could tell European style collective bargaining, which regulates mostly tariffs. So that's why they were called tariff agreements. And but I should notice that it was not very successful because economy was undeveloped. In socialist period after Second World War, collective agreements almost disappeared from our system. So exactly when I finished university, when I read in UK about collective agreement, it was something very new for me. I was beginner at the end of socialist period, and I was surprised, what is that? And that's why we, after abandonment of socialism, we re-established collective agreements. So we have period maybe 22, 23 years of collective bargaining. Of course, it is regulated by our constitution and by our labor code. Now, labor code is 2005. And as professor said, they wanted to have a catalyst role to the collective bargaining, but I'm not sure if was it successful, because economy cannot change in a moment. You need time to transfer economy from socialist to market economy. And that's why I could tell collective bargaining is successful, but needs to develop more. It is short conclusion about collective bargaining. Of course, for collective bargaining, you need trade unions. The first, it is depending on strong trade unions. And we are always, we have sometimes, I could tell, hybrid labor relations, hybrid solutions. So at the paper, we have 26,000 unions, labor unions, which is very great number. But it is because we registered each unions in enterprise. That's why we have. Exactly, we have three, and I could tell 4 strong unions, which are exactly not very strong because we have a declination of trade union members in last 10 years. I think it is the fault of unions, which are not enough strong and disunited. They don't work together. There are some cases, for example, in educational system, when they work together, they have strong collective bargaining. They are very successful. If they are not united, it is not so strong collective bargaining. And that's why I think we need more united trade union movement. As I said, so I will not show you all my text that you can read my presentation, I hope. What about participation? It is not popular in Serbia, especially because we had before in socialist period a self-government, what was not successful experiment. It was maybe good idea, but not very successful. So now it is not very popular participation, and also trade unions are strongly opposed participation because they consider their workers' participation as means of weakening them to have less unions. So to have a weaker role. I heard data from Kostas, very good data. We don't have data in Serbia, very modest data. So I cannot give you number and coverage. I can speak only in a level and moderate estimation. In public sector, we have great coverage of by collective bargaining because exactly we have strong public sector. Private sector is developing and it is not so enough strong. So collective bargaining is not enough developed. And there is a tendency of employers not to conclude collective agreements. They prefer to regulate labor conditions by working rules because they have more freedom to do that as they want. So it is like that. About room for promotion, I will speak in my conclusion. Impact of globalization. Yes, there is problem of globalization because there is a declination of number of full-time employees. We have such problems, and there is trend of flexibilization, bigger use of flexible working relationships, and also there is false flexibilization because we use false flexible working form instead of full-timers. So we have a declination of full-time employees. Maybe it is the cause of declination of membership of trade unions. Which subjects are for collective bargaining? I could tell typical, traditional wages, working condition, without a lot of innovation. I will speak about that later. So you can recognize also at my presentation, which are exactly, which are subjects in reality. As a professor said, often they repeat the rules of labor legislations. There is not innovative solutions in such collective agreements, and I think it is the weak side of our collective bargaining system. I think that's why, because it shows that it is not very developed, because they don't intervene as they could in such cases. It was, for example, the case of COVID, but I will also speak about. We don't have regulation of minimal salary at national level. There is a very simple cause because there is no national collective agreement. But I will show it later. New issues, new topics in collective bargaining are new, as I said, because I think the trade unions are not enough aware about new topics, about new categories of workers, which I would like platform workers. It is a very good idea from Greece to improve and to make a collective bargaining for platform workers. We don't think about that. It is, I think, far from reality that they will recently collective bargaining. So, what about COVID, which we don't like to speak, but we need to speak. In COVID circumstances, unions were completely shocked and unprepared for such circumstances. We had great uncontrolled suspension of many human rights and human rights of employees. They didn't react. As I said, they were shocked, unorganized, unprepared, and exactly they emphasize their activities that during this period to preserve jobs, for job security. It was the main activity. The bargaining was exactly at the minimum level only when there was expiring of collective agreement, there was renewal of the existing. So they were exactly confused with new circumstances, and they didn't use the advantages of collective bargaining in such situations. So, do we have a regulation about new forms of employee, and what is the connection with collective bargaining? There has not been exactly focus of our government and or our trade unions on platform work. So they are completely unaware of the problems in this area so far, and it's pity that unions have not tried to organize workers in non-standard forms of work, so there is no collective bargaining. We have obstruction exactly in our labor code, because when they speak about unionization, it is only for employees. They use term employees, but our constitution doesn't speak about the right of employees to make trade unions. They speak about right of unionization, of right of association. So we could use that possibility to organize such greater and greater. Each year, more people are working for in non-standard and non-stabilized forms for work. What about financial crisis and companies and collective bargaining? Exactly, crisis has diminished the importance of already minimal company bargaining. So collective bargaining only survives in public enterprises in an essential sector where works had a good negotiation position, because state and the society cannot function without such enterprise or such sector, education, etc. Which are levels of collective bargaining? Formally, typical, like in other countries, national, branch, and collective agreements with the employer. Now we don't have a general collective agreements. We had one in 2008, and it expired at 2011, because collective agreements are lasting for 3 years. I have another presentation, but this is the old, so you can see one sentence in Serbian. But I translated it. So I sent 2 presentations. If I find, don't be surprised. So we have one interesting solution. If there is no union in the is not organized in enterprise, then employees can bargain themselves. If they receive authorization of at least 50% of total number of employees, they can make one kind of tariff agreement. And This agreement ceases to be valid on the day the collective agreement enters in force, if they conclude a collective agreement. What about decentralization? We have opposite trend. Most European countries has, or in the world have, trends of decentralization. But because of our market economy is still hybrid, with there are a lot of enterprise, but they, as I said, there is tendency to regulate unitarily with the working rules. So that's why we don't have a great role of collective bargaining at the enterprise level. So there is no decentralization. We exactly have centralization toward to the branch or sectoral collective agreements to regulate labor condition. What about principle of favor? In reality, it is forbidden to make and to have worse working conditions than in a legislation. This principle was set 30 years ago, so we don't have that possibility, and only collective agreements can only make a greater rights and more favorable working condition than the right and conditions stipulated by the law. Application, I could tell it is classical, but the good things that collective agreements has a strong legal effect by the labor code because they are source of law and they have priority over labor rule book or working rules, as you say, and employment contracts. So that way, exactly, legislator tried to encourage collective bargaining in practice, but I think it was not catalyst effect, as Professor said. It should be. So you see personal scope of application, as I say, atypical. There is possibility to extension of collective agreement to make equal working conditions and salaries, and it is not rare. It is using often that a branch or sectoral collective agreements be extended to cover all workers in the country. They are exactly national collective agreements. What about, I could also say, new trends? Is there collective bargaining for economically dependent persons which are equalized to employees? Our legislator, our trade unions still didn't think about it. It is, I could tell, conservative approach to the trade union organization and collective bargaining. So social partners are not aware about new economically dependent persons and the trend that they should have possibility to bargaining because they are in similar position. What about enforcement of collective agreements? It is also the same, as I said, and as I said, it is good a solution that the collective agreements has just after laws legal effect. They are just after, so it is a great possibility to strengthen the collective agreement. And now, settlement of labor disputes. The role also. I made new slide, so here should be also courts and informal mediation. Exactly 5 slides, but I will explain so you will not miss that. First, we have ad hoc arbitration, which would be used for interest disputes if the parties cannot conclude collective agreement within 45 days. Or you have arbitration for legal disputes. If there is a dispute about implementation of collective agreement. Exactly, I don't know for any arbitration in practice, in reality. Maybe there was 3 to 5 It is very rare. What is exactly used is conciliation by the Agency for Peaceful Settlement of Labor Disputes, which is settled on 2005. And I could tell this procedure is becoming more and more popular last years, more and more used, because parties, social partners are more aware how it can be successful, that it can help to them. So it is, I think, good side. As I said, we need time. We were long in socialist period, and people should work how to learn how to work in market conditions. And collective bargaining is very connected to such situation. We also have one possibility for preventive mediation, where conciliators can provide assistance to the parties of collective bargaining. And improvements, what should we do? I think we should strengthen unions. Employer organizations are also weak and they are not representative. It is also a problem of our industrial relations. Of course, we should allow unionization of platform workers. It would be help to collective agreement. Thank you.
Ευχαριστούμε τον καθηγητή κύριο Γιαζάρεβιτς για την πολύ ωραία εισήγησή του. Έτσι λίγο να υπογραμμίσω κάποια σημεία. Μπορεί οι χώρες μας να είναι κάπως στην νεωτερική εποχή, είναι λίγο διαφορετικές πορείες, δηλαδή εντάξει ήταν η καπιταλιστική Ελλάδα και η σοσιαλιστική πρώην Σερβία, αλλά πλέον αντιμετωπίζουμε μια κοινή πρόκληση όλοι πλέον στα Βαλκάνια και η κοινή πρόκληση είναι η παγκοσμιοποίηση. Νομίζω αυτό από μόνο του καταλαβαίνετε τι θέλω να πω, βάζει πάρα πολλά προβλήματα, πάρα πολλά διακυβεύματα, γιατί πρέπει να ανταγωνιστούμε άλλες αγορές εργασίας, οι επιχειρήσεις που είναι πολύ πιο, σέβονται πολύ λιγότερους κανόνες εργατικής νομοθεσίας. Και σε αυτή την προσπάθεια να αντιμετωπίσουμε την παγκοσμιοποίηση, όπου θα έλεγα και το κλασικό δίλημμα των συνδικάτων είναι να περασπιστούν τις θέσεις εργασίας ή τις συνθήκες εργασίας. Πολύ δύσκολο δίλημμα. Προσπαθούν οι χώρες μας και οι αντίστοιχες νομοθεσίες να προσαρμοστούν στη νέα αυτή πρόκληση, όπως και να απαντήσουν σε νέες προκλήσεις, όπως είναι οι νέες μορφές απασχόλησης, οι οικονομικά εξαρτημένοι μισθωτοί, οι πλατφόρμες. Όλα αυτά είναι καινούργια ζητήματα που θα πρέπει ο νομοθέτης και οι κοινωνικοί εταίροι να μπορέσουν να τα απαντήσουν. Κράτησα επίσης ότι υπάρχει το δυνατό δημόσιο, φυσικά όπως και εδώ πέρα. Τα πράγματα είναι πιο εύκολα στο δημόσιο, τη διαπραγμάτευση. Δεν έχουν την αποκέντρωση όπως και που είναι μια σύγχρονη τάση στην συλλογική διαπραγμάτευση στις δυτικές χώρες, στη Σερβία. Και θα έλεγα, είναι τα πολύ λίγα που συγκράτησα από την εισήγηση την πολύ κατατοπιστική εισήγηση του κ. Γιαζάρεβιτς. Θα έχουμε τον καιρό να τα συζητήσουμε και μετά τη λήξη των εισηγήσεων. Και τώρα δίνω το λόγο στον καθηγητή, το όνομά του είναι πραγματικός Νιώτης Γλωσσοδέτης. Είναι καθηγητής στη Λευκοσία. Είναι εμπειρογνώμονα σε πάρα πολλά στην Ευρωπαϊκή Ένωση, έχει γράψει πάρα πολλά γι' αυτός και θα μας κατατοπίσει για τη συλλογική διαπραγμάτευση στην Κύπρο. Κύριε καθηγητά, έχετε το λόγο. Μέχρι να εγκαταστήσουμε εδώ πέρα τα τεχνικά μας.
Thank you very much for inviting me, and it's a great pleasure to be here. I thank Kostas Papadimitriou, the professor who I know for many, many years now. And after 22 years of coming back to Thessaloniki, it's great to see, to be back here, even if the weather has been a bit problematic for us. We live in a very, very, very difficult and strange times. And my presentation will be to examine how the Cypriot collective bargaining system has adapted to the current climate. And as the chair of this discussion today rightly said, we're facing incredible challenges, one after the other. The Cypriot labor relations system is dates back to the 1940s, when Cyprus used to be a British colony. Now, the interesting thing about it is that we have a very strong tripartite tradition. And there is a paradox operating here, in that on the one hand, we have a corporatist tripartite system whereby organized labor, organized employers, and the state are engaged in a regular dialogue which regulates employment. On the other hand, we have a country which, like many other Southern European countries, like Greece, is based on the dominance of SMEs. So in that area, the regulations are, and the absence of trade unions makes things very, very, very difficult. And I think that's a paradox we live in. In other words, we have both a system which is highly regulated, based on good labor relations, and on the other hand, we have sectors of the economy which are based on informal family type or small businesses, which has to be regulated by law if we go to court, but we don't have organized labor there. Now, the tripartite system of Cyprus is based on this idea and has been strengthened since independence in 1960. And I would say that it reached its peak, the highest high point, in the late 1970s with the revision of the Industrial Relations Code, which was signed by the social partners in 1977. And this is, it's crucial to say, and I'm quoting here from the Ministry of Labor and Social Engineering website, which underscores that even though the code is a voluntary agreement, it is highly respected by social partners, and they very rarely fail to adhere to its provisions. So we have a system which is extremely powerful. Now, the dominance of these regulated employment relations continued, I would say that up to the 1980s, but since the 1990s, we have the rise of various services around tourism and the restaurant sector, like Greece, like Italy, like other Southern European and many of the Eastern European countries recently. But we also had this rather embarrassing financialization. It's embarrassing because I don't know if you have seen the Al Jazeera documentary about the sale of golden passports. Now, financialization with its ludicrous financial services has resulted in a transformation, at least for the financial sector of the economy. And we could say that that area is not regular, and that has been the trend. Also, there has been an issue, there are issues relating to the lack of regulation in areas such as the construction industry, which is again not regulated as much. But I would say that this is the Industrial Relations Code is crucial because it sets out the basis for negotiations for everyone. So in public and in private institutions, this is followed wherever there are trade unions and there is a system of collective bargaining. And the code consists of mainly two parts. The first part is it provides for the substantive provisions, and it allows for the two participating parties, the trade unions and the employer organizations, to recognize and ensure certain fundamental rights to free collective bargaining, and these are the following four. So the right to organize, the right to collective bargaining, collective agreements and joint consultation, the definition to negotiate negotiable issues through collective bargaining, joint consultative issues and management prerogatives, and strict adherence to the provisions of the International Labour Conventions, which the government has ratified. Now, the second provides also for important procedural provisions, which allows for procedures, what happens if we disagree. So there are time limits, there are issues, and this is highly regulated. And I can tell you this also from apart from my legal capacity as the president of the Union of the Lecturers of the University of Nicosia, and I'm very pleased to hear some of my colleagues present here. We are one of the few universities which has a collective agreement which regulates the key terms and conditions for in our field, and it's a private university. It's not a public university, and we are the only one which has this system at a local level of organization. I think this gives you an idea of how important sectoral or business level of organization is in Cyprus because of the system of collective bargaining that we have. I think if there is something that has to be stressed, is the relationship between collective labor law and individual labor law in the context of the British system as it is implemented and practiced in Cyprus. And I think this is a source of confusion for many. I've seen even textbooks written by lawyers which fail to understand how the two are actually connected. The collective agreements in Cyprus are the result of the free bargaining processes between the employers, organizations, and the trade unions. And they are voluntary. They're often said in this sexist language that they are gentlemen's agreements, yes? Now, this means that they're not binding on the parties which negotiate and sign them. However, the important thing here is how they regulate industrial and labor relations. Now, at one level, of course, they create what is considered to be a customary system, and they set the standards, the rules, and understandings of how this operates. But the key thing, and as a lawyer, as well as a trade unionist, is can we get them implemented? Are these applied in practice? And eventually, in the final analysis, can you get implemented in a court of law? And I think this is where there is this important aspect. And I think if anyone who knows the British, the English system of how it operates, this is based on the way in which the terms of the collective agreement are inserted in individual contracts. And there are three basic principles. I won't tie you through the details of the case law, but I think it's important to know how this operates. Again, and I insist on this because I've seen textbooks on Cypriot law which actually fail to recognize this. So, British common law principles provide that for incorporation of the terms of the collective agreement within individual contracts of employment, but three conditions must apply which I explain below what it means. And this is very important because this idea that they're not binding on the parties, how can they be binding on the individual workers? So the first condition is that the terms of the agreement must be applied in the industry or district, and the wage and codes become what is considered to be crystallized customs. So if they become customary, and this is the practice, then even though there is no automatic incorporation in the individual contracts, labor contracts, the courts will take this as a key area. So that's the first condition. The second, there is British case law, which was confirmed by Cypriot case law afterwards. Now, the second principle, the second condition, it has to be, the specific terms has to be construed, has to be understood as the basic in the context of the specific contract of employment. It must be understood and construed by the behavior of the parties in the specific contract, that it is part of this. So the idea here is that there is a practice and there is a behavior that allows you to show that it is practice. So for instance, in my university, just to give you an example, if there is, and it has happened in the past, if there is an agreement of a contract which is below the level set by the collective agreement, because obviously a young lecturer who is desperate to get a job says, look, I'll accept anything. In fact, I can teach for free or whatever it happens these days. And they sign terms that are inferior to the contract, to the collective agreement, usually, and the union finds out, we'll go to the management and say, look, this is the situation here. That's the custom. These are the standards. These are the rules. And in that context, even though the parties, there is freedom of contract and the parties may contract anything they like, if it comes to the level of the union, this is what will happen. And they usually, the employers will comply. And even if we go to court, it's likely to be complied with too. The third principle is that the terms to be incorporated must be suitable. Now, this is what a suitable means in this context. It basically means that they are referred to the types, the nature of these terms and conditions must be such that is quite specific, such as pay, such as working time, such as issues relating to the early retirement, issues relating to redundancy, procedures about disciplinary issues, that kind of the nature of which makes them suitable. If it's just statements or general intentions whose nature is declaratory, then they do not apply. Now, this is basically what Cypriot labor law deals with this matter. And I spent some time explaining this because I think it's very important to see the connection between individual and collective labor law as it applies in Cyprus. And I think it's a very, very promising area. Now, this is also important, given that what the chair has mentioned earlier, with the current challenges we're facing and what my colleagues have discussed earlier, we are facing types of employment, like new types of employment, which requires that we as a legal community, employers, trade unions, social partners, think and imagine ways of resolving such issues. When we're dealing with platform workers, when we're dealing with the extension of digitalities, which has become very much part and parcel of how we conduct our work after the pandemic, it's very important that we deal with such issues. Now, in the context of Cyprus, I can say that there are 2 or 3 important initiatives that began to take place after the economic crisis. And here I make a parenthesis. The economic crisis hit Cyprus rather late. We started around 2012. Greece started earlier. Many other European countries started earlier. So after 2012, we had a memorandum of understanding, which and the haircut in Cyprus, which meant confiscation of deposits, which made things very, very difficult. And workers, trade unions, and employers have made agreements to have a reduction in their wages for a period of time. But we relatively quickly managed to exit the memorandum of understanding. The crisis finished, and we kind of returned into some sort of normality. Of course, when it comes to the level of wages, Cyprus now is back at the period of 2013. Not we are there in terms of where the income is for wages, but there has been a development in a positive way. I mentioned a couple of initiatives. One of the initiatives that's very important is to do with the way in which, during the pandemic, and as we're exiting the pandemic, there has been an extension of the wages and rights of workers who are in the hotel industry and have suffered a lot as a result of the pandemic. This has been a positive development. It is regulated by law, and I'm referring to an old decree law, which in Cyprus, as you know, we don't have a system of national minimum wage. We have a colonial law which allows the minister, where there is a weak bargaining position by one of the two parties, the trade unions, can issue decrees on the minimum levels of income in those specific jobs, in those specific industries. So this has been an extension of that situation. The second initiative, which is important, is what has happened with the construction industry, which allowed for regulation and the extension of rights based on the collective agreement between the two sides to all areas except wages. The idea is to extend it possible to wages. Now, there is a disagreement on how to deal with the issue of the new directive on minimum wages, and now there's a debate in Cyprus. There's convergence, but there is still disagreement. Should we have a system of national wage, which is the floor, or should there be a system based on the current traditions in Cyprus? And I say the current traditions because we have a system of collective bargaining, which covers pay a little, under 50% of workers, multiple levels, at different levels. I can't give you the statistics, the great statistics that Kostas gave us for now, for what has happened in the past period. We would say that there are 250 to 300 collective agreements signed in Cyprus. Bear in mind the size of the country. Yes, we are talking about a very small country here, not like Greece or other friends here. And they are signed at different level. So it's not like a one level thing. So it's very important to think in the context of how we adapt the tradition, and we're based on the traditions that we have in Cyprus itself. So in terms of these current challenges, I would say that this is one of the discussions we have. Now, of course, there was a kind of dynamism in thinking about different initiatives, and I mentioned two: the initiative with the construction industry. There was also a third initiative. There was the initiative with the hotel industry, and this can be extended further in other areas. The third initiative that was important was that we had a law which allowed for the recognition of trade unions by employers. We set a procedure for recognition of trade unions at local level, because there were a number of employers that refused to recognize trade unions. So the procedure is there. It's a bit bureaucratic, it has problems, but it has been a positive, based on consensus, based on the good relations between employers and employees through the different processes of the tripartite system of Cyprus. And I think this was the third initiative that we had there. Now, with the pandemic, and now with the war in Ukraine, which brings us to another level of crisis, many fear, trade unions and from employers' organizations I have spoken to, fear that this will delay the kind of the processes of thinking ahead. My response to that is that precisely because we're facing very, very turbulent times, we have to become much more imaginative, much more assertive in creating conditions to protect those who are in positions who cannot be protected by the existence of trade unions. And there are sectors of the economy which are not regulated at all. And there is a rise in the precariousness. I can show you figures. There's no time for that now, but we can show you that there is a rise in the numbers of precarious people working in uninsured sectors. There are issues relating to which show that we're dealing with the employment. It's a kind of a pseudo subcontracting situation, which I think are challenging, challenges in front of us. Now, just to go back to filling some of the gaps that Kostas Papadimitriou mentioned earlier, I would say that when it comes to mediation and arbitration, Cyprus has a very good system of mediation. The industrial relations system is actually very, very robust. Most of the disputes are resolved, over 90% are resolved beforehand. And once they go to mediation, they are usually resolved. It's very, very rare that we have strikes at the end. And that's because of the strong role of the mediation system and the role of the specialized unit of the Ministry of Labour, which has this tradition. Now, there are some cases which go to arbitration if both parties agree. It happens very, very rarely. Both parties have to agree. And there is also an issue there whether these decisions are actually binding, although the law says that if they agree, they would be binding, they would be final. Although some of them end up in courts. But because of the system of mediation, because there is such a robust system of mediation, and there is a strong tradition of tripartism, arbitration when it comes to labor disputes is rare. Although Cyprus is a big arbitration country for other types of businesses, shipping, all types of things. And there are many well-known Cypriot lawyers who are arbitrators in other commercial areas. But rarely does it happen in labor law. And I think this is interesting. I don't know what would happen in the future, but so long as there is a strong presence and an effective role of mediation, arbitration becomes less important in the context of Cyprus. So I would like to conclude with just a couple of thoughts on what I see will happening in the future in terms of the future of collective bargaining in Cyprus. I think with the globalization of the economy, and as I said, Cyprus is a very, very globalized country. It is very much exposed by the turbulences that are taking place. For instance, at the moment, because of tourism, the sanctions will affect definitely the hotel industry, and that will be a major issue. There's also other types of dependencies. For instance, with the financial sector, and Cyprus is a big financial and banking country. There will be a negative effect in the finance sector. Now, this will is likely to have a major effect on, for instance, the construction industry, because much of the capital that was used there was actually used for the current development in this in construction. So this is likely to have a negative effect on Cyprus, on these sectors, and of course this will mean that the employees and companies will be under immense pressure. Now, this would be another type of challenge for collective bargaining in the years to come. It's likely that we will continue to see a rise in precarious and informal types of employment, although it has to be said that the crisis in the financial sector may mean that people will be, employees will try to seek more regular types of jobs rather than go for these ludicrous types of jobs. So this will also be an issue. But I think the challenge for employers and trade unions is to think around the problem to ensure stable employment in the crisis in front of us. And I think that the traditions and the development of previous initiatives have to continue after the pandemic is over. Now, the pandemic hasn't really, the trade unionists say that it hasn't really affected the number of conclusions of collective bargaining they had. They said the numbers are the same. What they have found is that, they argue, is that there has been more applications of certain sectors. There have been more disputes, and many of the disputes are taking place in the hotel industry. The response by employers is that in the current crisis, we have coped very well. There has been a very good cooperation ensuring employment for the vast majority of workers, and we will be gradually exiting the crisis in front of us. Therefore, it's likely that from the pandemic we can learn that good cooperation and good relations would resolve problems ahead of us. So let's hope that that will be on that positive note. It will apply to everyone. Thank you.
Ευχαριστούμε τον καθηγητή κύριο Τριμικλινιώτη για την, θα έλεγα, αισιόδοξη εισήγησή του. Τα άκουσα λίγο πιο αισιόδοξα από τους άλλους. Και νομίζω ότι μας έβαλε, αν λάβουμε υπόψη την κυπριακή εμπειρία, το νέο στοιχείο που είναι η ενσωμάτωση μιας αγγλοσαξονικής παράδοσης, όπου, από το κατάλαβα εγώ, και έτσι είναι μάλλον, η συλλογική διαπραγμάτευση δεν χωράει σε ένα νομικό πλαίσιο πάντα. Και πιο σημαντικό είναι ο λόγος των μερών. Γιατί εν τέλει η συλλογική διαπραγμάτευση είναι ένα contract, είναι μια συμφωνία. Δηλαδή, από ό,τι το αντιλήφθηκα το σύστημα, είναι πιο αυτόνομο, έχει και λιγότερα στοιχεία ετερονομίας. Αυτά θα τα συζητήσουμε όμως. Πιστεύω ότι ο κοινός παρονομαστής όλων αυτών των εισηγήσεων είναι ότι η δυνατή ιδέα της συλλογικής διαπραγμάτευσης, είτε στη Σερβία, είτε στην Ελλάδα, είτε στην Κύπρο, είτε στις άλλες χώρες της Βαλκανικής, είναι ότι όλοι μαζί μπορούμε καλύτερα, και αυτό ισχύει όχι μόνο για τους εργαζόμενους, αλλά και για τους εργοδότες, γιατί εξομαλύνουν και εξορθολογίζουν τους όρους ανταγωνισμού. Τώρα ο λόγος είναι σε εσάς, να θέσετε ερωτήματα, να μας πείτε τις αντιδράσεις σας σε αυτά που ακούσατε. Έχουμε μισή ώρα. Σας παρακαλώ να μην φοβηθείτε, χωρίς ενδιασμούς, να συμμετάσχετε σε αυτή την... Κυρία Ντότσικα.
Thank you very much for your very interesting presentations. I would like you to elaborate on the system of Cyprus and on the system of Serbia on one issue, that is the favorability clause and the possibility of extension of collective agreements. Do I understand well that in Cyprus the system does not provide for the extension in the way we understand it in the European basic legislation? So my reading was that there is no concept of extension of collective agreements. Do I realize it well? And if it is so, then would you please elaborate on the way the collective agreements get their implementation in a vast number of employers and employees, provided that these employers and employees are not members of the signing parties. And that comes to another issue, which is the density of trade unions and the density of the unions of the employers. And that gives us a huge problem in terms of the small enterprises where there is hardly any representation. So although they are not, excuse me for the expression, a black market, it is quite a clean market. However, lacking the representation, how do collective agreements might have a possibility of being applicable to them? So would you please elaborate on this issue? And also, you have mentioned that you have a very effective system of mediation that leads you to a very limited use of arbitration. And you have mentioned that this is operated through the Ministry of Labour. And I want to realize if it is the Ministry of Labour or if there is another structure also in Cyprus which has a kind of similarity, like the ACAS of the UK, because whatever you were mentioning, it reminded me of the Trade Union Labour Relation Act of the 1975. So I wonder, do you have something like ACAS in Cyprus, which has certain similarities to our ΟΜΕΔ in Greece? So I would like your response. And as far as the system of Serbia is concerned, I want to understand if there is an important trade union density in your country and for the employees, and another kind of density for the unions of the employers. Whilst if you are lacking possibility of representation, then I do understand how the steps towards collective bargaining seem to be so slow. And I would also like you to give us an impression on how does the system applies for the collective agreements when they come to be extended, that means to be valid for members, for persons as employees, and for legal entities as employers when they are not members of the signing parties of the trade union. And will you please tell us if your collective agreements have an enforceability similar to ours, that is, they are binding as such, or if they are binding as gentlemen's agreements, as we have heard for the system in Cyprus. And thank you very much again.
Κάποια άλλη ερώτηση, κάποια απορία, τοποθέτηση, για να κλείσουμε στο τέλος. Ο κ. Σκανδάλης.
I would like also to thank all of the speakers for the great reports. I think it was very illuminating, and we had the possibility to enrich the dialogue with the perspectives of other countries. Only two points I would like to bring to the discussion for the Cypriot and Serbian system. So starting from the Cypriot system, Professor Trimikliotis, I can understand why the scholars, it is difficult for the scholars to understand how the structure, how the system is structured, because it is quite ambiguous, I would say. So in order also for the Greek, our Greek audience to be more clear, I would like to bring into the discussion the normative and the contractual effect of the collective agreements. So in Greece, we have the contractual part of the agreement, because essentially it is agreement, but also we have the normative aspect, meaning that the agreement regulates issues in an obligatory way. So I was wondering whether we could translate the Cypriot system in this way, because it is clear from what you said that they are not officially legally effective. However, on the other hand, they are respected. So maybe the normative aspect of the agreement would be an easier way so as to understand and become more obvious also to us how the system operates, because it's really interesting, and I also understand that it is not exactly the common law, and this is why it is extremely interesting for us to have your speech here today, and thank you for that. And also on the mediation issue, also a very, very interesting point, because also in Greece, it is very important for the dispute to be settled at the mediation stage. As we all always say, the arbitration should be the last resort, and also there are some ambiguities also in theory whether we should have unilateral arbitration or not. I would not like to get in more detail on that, because there are a huge literature on this issue. In order to be a bit more skeptical, it is very, very good that the mediation is successful. However, on which basis? Maybe it is also an issue of very few collective bargaining, very few instances of collective bargaining. So we have the density of collective bargaining is at a good stage so as to say that also the mediation system is effective, or we should combine the success of the system with the issue of less collective density. And only a question for the Serbian system, also a very, very interesting speech, and thank you very much for the representation, and thank you very much for that. I would like some more details on the issue of the binding effect of the agreements and the way that they can be declared effective, as generally applicable in the fields of sector and profession. Thank you very much again.
Το λόγο έχει ο κύριος Κουκιάδης.
Μία ερώτηση για την Κύπρο και για τη διαιτησία. Και είναι μια προσωπική απορία. Πριν από 15 χρόνια είχε προκύψει μια μεγάλη διαφωνία ανάμεσα στο παράτημα, στο υποκατάστημα της Εθνικής Ελλάδος με τον τραπεζίτες, τραπεζοπαλλήλους των υπολείπων συμβάσεων, υπολείπων τραπεζών. Και δημιουργήθηκε μια επιτροπή από το Υπουργείο Εργασίας με πρόεδρο τον εισαγγελέα Κύπρου, έναν εκπρόσωπο των τραπεζοπαλλήλων και έναν εκπρόσωπο των τραπεζών, και από την Ελλάδα είχα οριστεί εγώ. Έτσι πολύ είχα την τύχη να συμμετάξω σε αυτή την διαιτητική, θα λέγε, επίρρηση που κράτησε περίπου ένα εξάμηνο. Περίπου κάθε μήνα πήγαινα στην Κύπρο, συζητούσαμε, μεγάλο διάλογο, δημιουργείχα πρακτικά. Ήταν εντυπωσιακή για μένα αυτή η εμπειρία. Το ερώτημα λοιπόν είναι πρώτον, και μάλιστα από ό,τι θυμάμαι, ήταν η πρώτη φορά που εφαρμόστηκε αυτή η διάταξη στην Κύπρο. Άρα λοιπόν ρωτώ, αυτή είναι η κλασική διαιτησία ή έχουμε κάνει διαιτησία? Και κυρίως αυτό το σπάνιο ισχύει και για άλλες περιπτώσεις, τελικά δεν υπάρχουν καθόλου διαιτητικές επιλύσεις. Πάντα είχα την απορία αν αυτό το σύστημα ισχύει για όλες τις περιπτώσεις ή για κάποια ειδική περίπτωση, και σε πώς θα είναι ευχάριστο, θα είναι θετικό να εξηγήσετε εάν πράγματι η διαιτησία είναι τόσο εξαιρετική ώστε να γίνει μία στα 10 χρόνια ή όχι. Αυτή είναι η βασική μου απορία. Ευχαριστώ πολύ.
Και ο κύριος Σιδέρης, τελευταία ερώτηση, γιατί μας πιέζει πλέον.
Ευχαριστώ. Από τη Σερβία. Επειδή μας είπε στην ομιλία του ότι δεν ενδιαφέρονται και πολλοί οι εργαζόμενοι, αν κατάλαβα καλά, να συμμετέχουν ως μέλη στη σωματεία, ήθελα να του ρωτήσω αν ένας εργαζόμενος του ιδιωτικού τομέα στη Σερβία μπορεί να γίνει μέλος σε πόσα σωματεία. Μόνο σε ένα ή σε περισσότερα? Αυτή μόνο είναι η ερώτησή μου.
Ωραία. Ο καθηγητής κ. Γιαζάρεβιτς, προφέσορ.
Either worker may participate at more than one trade union.
Oh, yes. Okay, I understood.
Yes, the question of the first question was about the extension, the right to extension. Now, this is collective agreements, once they are signed in a sector, they are considered to be the norm, and they cover everyone, not just those who are members of the union, of course. So it is, in that sense, covered everyone. In my university, not everybody is a member of the union. It covers everybody in the specific business that is carried out. Now, there are sectors which, if they don't have, it is an issue of the density of the employers and the trade unions, and that is an issue that creates certain problems. If the employers are not members of the ΟΕΔ, like SEV in Greece, yes, and there is an agreement between ΟΕΔ, the employers, and the association and the trade union, and somebody is not a member of that does create an issue. So it's one of the areas which is recognized at the moment and is as a problem, and what happens in those areas. Trade unions in the past have not been very keen on creating a legislative framework that extends the collective agreements to the areas in which they're not covered by trade unions and employers. So that has been in the past. Gradually, as a result of the lowering of the numbers of the density of trade unions, the weakening of trade unions, they have accepted, they're increasingly accepted that you can, and there should be a process of extending them. The question is agreeing on how this will take place. Bear in mind that a number of we have a system which does regulate the basic terms of employment. So the basic rights are covered. So, for instance, holiday pay, 13th salary is usually done on the collective agreement level, and this is considered to be part of pay. Hours and that sort of thing is already regulated. In areas that there is no tradition of trade unions, we have also the possibility of the minister issuing decrees, which are binding by law. They are decrees, and they set the minimum, including wages, as well as the other terms and conditions. Now, that's the basis on which some trade unions want to implement the minimum wage system. However, there are two major trade unions in the private sector, PEO and SEC. SEC wants a national minimum wage. It says, look, enough of this, we need a national minimum wage, and that will be the basis. PEO wants to retain and extend the current system. The government has pledged to implement the minimum wage system. What it does, we will see what happens in the end. It was delayed because of and it's a pledge of the current president, whose term expires next year. So within the next few months, we will have a system of minimum wages, and we will see a system extending this further. So that's the situation. Now, what is the exact procedure that happens in terms of the ministry that is in charge here? We're dealing here with a system whereby it's a committee within the labor ministry. If we look at the code, the procedural level of the industrial relations code, it provides that there is an industrial relations committee which deals with this matter. It's not like ACAS. It is part of the ministry. ACAS is something different. ACAS is a body outside the ministry. This is part of the ministry. But because of the long traditions from the 1960s, from the 1940s exactly, that it has developed, we have a system which allows, and it's recognized, and it plays a genuine mediation role. Even though, I mean, the mediators have this very important mediation role, and it operates more or less like ACAS, but it is part of the ministry. But if there's no agreement at the end, in other words, if the two parties don't agree with the mediation proposal, they are free to act once they follow the procedure. The workers can go on strike as a final result, and the matters may reach court eventually. So that's how the system is resolved. In other words, the mediation is not, the decision is not binding. And this is different from the arbitration situation, which Professor Koukiadis mentioned earlier, he was part of. It is very rare. It's a system which is very rarely used. It is possible, and that was the first time it was used. I'm not aware of any other cases since that we have used. It is cited in textbooks as the case. So, but it was, and it's cited very positively. So I don't know whether in the future we will see this developing in a positive way. A major challenge, and I think maybe I was too over optimistic, and I want to correct myself. A major challenge is the fact that we have a reduction in interest and levels of organizations on all sides, and the rise of informality and precarity is threatening the whole way the system is organized. That is a major challenge to think ahead, and how to organize in areas which don't have this tradition of unionization and working through collective bargaining. And I think that's something we will have to deal with in the future. Another major challenge, I mentioned this, but it wasn't very clear, is that even areas which are unionized, we have a larger number of individuals who are used as subcontractors, or and this is also happening in the public sector in particular, which takes a leading role. And it's a major, major challenge. And that undermines what we know as the norms and the systems as before. Now, something I forgot to mention, something about the way something about customary system in the way that the question that you raised about whether this can be used as setting the norms. Yes, the British system, as developed and as understood by the courts in Cyprus, is based on this idea that collective agreements create norms and practices. And these norms and practices become codes which acquire force like law, and the courts recognize them as the reality and what happens at that level. So the principle of favor operates in favor of these norms if there is an agreement below that level. So in that sense, it is a system which is not just normative in the sense that it's not binding. It's a normative that becomes in law binding by setting the kinds of norms and customs that become the established system there. Now, this is where the combination of the continental and the Anglo-Saxon system seems to be converging in creating such norms which create binding rights. And I think this has to be clarified and codified properly as a way forward, because by looking at what the case law and what this judge and that judge said is problematic. We need clarity in law. We need these codes to be properly recognized and to be properly codified for the future. And that's the way forward I see it. And that's the way also of dealing with the difficulties and the challenges ahead that we are going to be facing. Thank you.
Thank you. I will respect time limit that we have to finish. I hope I will be brief but clear. And that I understood correctly your questions. First was about the representativity of trade unions, about coverage of employers and trade unions. Trade unions are representative, especially in public sector. And because there was, from socialist period, some trade unions which are still existing, But we have some new independent trade unions which are exactly relatively strong in private sector. They are fighting for collective bargaining, for working conditions, and I could tell that they are becoming more and more successful. We have problem with representativity of employers' organizations. Exactly, we have only one, which representativity is ambiguous, because it is not organization of big employers. It is organization of craft on small, very small employers, self-employment people, craft. It is exactly I could tell craft union. So this representativity is problematic, but a state doesn't make problem for this, just to try to stimulate development of industrial relations. They respect this organization even if its representativity is under the question. Second one, scope of application. It is regulated by the labor code, so collective agreement is binding to all employees, even if they are not members of union. Because we have exactly multi-union collective bargaining. They can bargain each union which has representativity. A representativity condition in the employer is 15% of coverage of workforce. So each union which covers 15% can be member exactly of collective bargaining, and they will bargaining together. They will make a joint committee for bargaining, and by the law they should respect the people who are not organized. Their opinion should be included. How? I don't know. I'm exactly, I should tell that I'm mediator for more than 15 years. So I have experience in mediation. So I share this when I speak. I don't speak only like professor. I have a combination as mediator. So about binding effect and about extension. We have conditioned that collective agreement branch or sectoral covers more than 50%. And there was a demand from or employer side or either from a trade union side. So the ministry exactly makes a decision to that a collective agreement will be extended. It is not rare case. And also, but good good solutions that some employers can apply for exemption if they cannot stand such conditions for mostly wages and benefits that he cannot pay. They can be exempted. Generally, small employers. And the third question was about participation in more than one union. It was not exactly regulated. But for collective bargaining, for when we have the representativity test, which can be every 3 years, if there is representativity test, demand from employer or other union to test the representativity of union. The last membership, I don't know how we have special expression for membership certificate. The last is valid, so he can be a member of few. He can pay to be member, to associate with a few of them, but if there is a question of representativity, the last certificate for assembling is valid.
Ευχαριστούμε τους συμμετέχοντες και εσάς. Τώρα είναι ώρα για τον αδιαπραγμάτευτο καφέ. Αλλά μόνο για 1/4. Αυτό επιβάλλεται.
But I hope you can ask Mrs. Spears to send your presentation. We're going to practice that. 3 months to send a book.
So, dear colleagues, please take your places so that we can begin our session. If you are kind enough, please. So our next session in the panel, we have Professor Kazimir, who is connected online. Do you hear us?
Yes,
Do you listen?
I hear you.
Thank you. Very nice.
And
We have also,
I see you too.
with also Professor Vesna Simovic, and President of the Council of Judges of Montenegro, and Professor Ivana Gurev of University of Zagreb. Allow me to begin with a great thank to Mr. Papadimitriou and the ΟΜΕΔ for giving me the opportunity to chair this meeting, this session. As a judge, I don't have a great experience of mediation. I came across only with the results of the collective bargaining, but what I have experienced that I would like to point out is that collective bargaining is an accurate picture of the society, the economical stature, and the politics of each country. So it is very interesting to know the similarities and the differences. It is a very important first step if we want to achieve a goal that seems to be utopic by now, to achieve a minimum wage for every employee, which will allow them to live a decent and joyful life in their countries. So I won't keep you anymore with philosophy. We are a bunch of 4 wise women. I hope you have noticed already that. And I'm giving the floor to Mrs. Kazimira.
Thank you. Dear colleagues, allow me to start with 2 preliminary remarks. First of all is my great thank you to the Organization for Mediation and Arbitration in Greece, and personally to my colleague and friend, Professor Papadimitriou, to invite me to take part in this very, very interesting conference. And my second remark is the congratulations of Bulgarian Association for Labor Law and Social Security for the 30th anniversary of this organization. And also congratulations on behalf of the Supervisory Board of the National Institute for Conciliation and Arbitration. As we all know, collective bargaining and conclusion of collective labor agreements is a basic institution typical for labor law only. It is a means of collective protection of the labor rights and interests of the employees. This paper, my speech, does not contain fundamental ideas, but it aims to present the situation in Bulgaria. In Bulgaria, collective bargaining and conclusion of collective labor agreements originated in the early 20th century. Initially, the legislation did not regulate the collective labor agreement as a contract binding on its parties. The struggle of workers, and in particular strikes, achieved this binding force. This period in Bulgaria lasted from 1905, when the first collective labor agreement was concluded in Sofia private printing houses, until 1936, when the first legislation was adopted. This was the Ordinance Law on Collective Labor Agreements and the Settlement of Labor Disputes in 1936. Collective bargaining and conclusion of collective agreements is a power tool for protecting the interests of employees. This protection is achieved through a bilateral contractual laying down the general conditions for rendering labor, which in many cases is more efficient than individual negotiation. The normative regulation of labor relationships is enriched through the collective bargaining. It is the second pillar of the legal framework. It establishes higher standards for protection of employees than the minimum ones set out in labor law. And on the basis of what is established in the collective labor agreement, in the individual agreements of the parties to the employment relationship, even more favorable conditions may be specified. Collective bargaining is also a key tool for settling collective labor disputes. The law on the settlement of collective labor disputes provides as the main means for settling these disputes the negotiations between the disputing parties and reaching an agreement between them, the effect of which is equivalent to the effect of the collective labor agreement. Unfortunately, in recent years, the conclusion of collective labor agreements in our country has been on a steady decline. According to National Institute for Conciliation and Arbitration data, 1,330 collective labor agreements were registered in 2011, and in 2017, only 1,015. Of these, at the enterprise level, some 922 agreements were concluded. At the municipal level, 87. At the level of industry or branch, only 6. This is mainly due to the economic difficulties for the employers, who cannot guarantee conditions that are more favorable for the employees than the working conditions established by law, and to the decrease in trade union association and in establishing trade union organizations, among others. The main national framework for collective bargaining and conclusion of collective labor agreements in Bulgaria is contained in Chapter 4 of the Labor Code. Separate rules are also established in other provisions. Other labor laws also regulate these issues, such as the law on settlement of collective labor disputes. The subject of the collective bargaining and of the collective labor agreement concluded as a result is determined by the range of issues on which the negotiations are conducted and which are included in the agreement reached. For Bulgaria, these issues are set out in Article 50 of the Labor Code. There are two groups of issues. First, issues of employment relationships. These are the relationships between the employees and the employer during and on the occasion of supplying labor force. These issues are prevalent in collective bargaining. Second, issues of social insurance relationships. The social insurance relationships are related to the material security of the employees when due to disability, maternity, and other reasons provided for by the legislation, they couldn't gain means of subsistence for their personal work. They are regulated in the Social Insurance Code, the Health Insurance Act, and the Code of Tax and Social Insurance Procedure, mainly by binding legal rules. Hence, there are fewer opportunities left for the collective bargaining. In order to be subject to collective bargaining and to be included in a collective labor agreement, the issues of labor and social insurance relationships must not be regulated by mandatory provisions of the law. Not regulated by mandatory provisions of the law are issues that are not regulated at all in any statutory instrument, issues that are regulated by dispositive provisions of a statutory instrument, and issues for the regulation of which a statutory instrument explicitly refers to the collective labor agreement. The provisions of the collective labor agreement should be more favorable for the employees than the ones in the legal acts issued by the state. Thus, a higher degree of legal protection is achieved than the one established in the law only as a minimum standard. The levels at which collective bargaining may be conducted and collective labor agreements may be concluded in Bulgaria are laid out in Article 51 of the Labor Code. The main level is the level of enterprise. Naturally, greater opportunities exist in manufacturing enterprises, where there is economic capacity to provide conditions that are more favorable for employees than those established by law, but there are certain opportunities in public enterprises as well, although still limited by the budget. Collective bargaining can also be conducted in municipalities for activities financed by the municipal budgets. A collective labor agreement may also be conducted at the branch level and at industry level. The right to conduct collective bargaining and to conclude a collective labor agreement rests above all with and is most often exercised by the employer. This is the employer in the individual enterprise as a place of employment. Collective bargaining may also be conducted by an employer's organization. This is the hypothesis of bargaining at industry, branch, or municipal level. The representative employers' organization is the competent body to conduct collective bargaining. In the individual enterprise, collective bargaining may be conducted and the collective labor agreement may be concluded by any trade union organization, regardless of its size, capacity of being representative, etc. However, the law requires only one collective labor agreement to be concluded at one level. This is to ensure unity in the rights and obligations of the employer and the employees. For the same purpose, the law stipulates that where more than one trade union organizations exist with one enterprise, they shall submit a common draft. If they fail to reach an agreement, each organization may prepare its own draft. All drafts are submitted to the General Assembly of Employees. The General Assembly of Employees decides which draft favors most the employees. The trade union organization that has submitted this draft shall conduct the collective bargaining, and upon reaching an agreement with the employer, shall conclude the collective labor agreement. Similar to the employers' organizations, trade union organizations may also conduct collective bargaining and conclude collective agreements at a higher than the enterprise level, only if they are representative. The main obligations in connection with the collective bargaining are those of the employer. The employer is obliged to negotiate, to conduct collective bargaining with the relevant trade union organizations. This obligation arises at the request of a trade union organization. The employer is obliged to make available certain information in connection with the possible conclusion of the collective labor agreement. This obligation arises at the request of the trade union organization which conducts collective bargaining. And the employer is obliged to inform the employees of the collective labor agreement. The trade union organization also has obligations in relation to collective bargaining. These are to, first, to submit a draft collective labor agreement, and second, to provide information to the employer concerning the number of members, not the names, of the trade union organization. The collective agreement is the legal act expressing the agreement reached in the process of collective bargaining. In terms of its form, a collective labor agreement is an agreement. It is concluded by means of an agreement between the employer or employers' organization and a trade union organization. In this sense, a collective agreement is an agreement between private entities. In terms of content, the collective labor agreement is a normative agreement. It is defined by its effect and legal consequences. The procedure for concluding a collective labor agreement shall be determined by the parties to the collective bargaining upon its commencement. The collective labor agreement is concluded in writing. This is the usual written form. What is special here is that the agreement is concluded in triplicate, one for each of the parties of the contract, and one for the respective labor inspectorate, where the agreement shall be registered. As a rule, the collective labor agreement is concluded for a term of 1 year, but the law allows the negotiation of another term of the collective labor agreement. The law establishes two hypotheses for extending the term and of the collective labor agreement, and namely, termination of the membership of employer in the employer's organization, which has concluded the collective labor agreement, and change of employer under the employment contract. Since the collective labor agreement is a normative contractual agreement, it is implemented under the individual employment relationships with the employer party to it. Directly by operation of law, without the need for any additional action, it is effective under the employment relationships of employees who are members of the trade union organization party to it. Not all employees in the respective company, branch, etc. may be members of the trade union organization that concluded the collective labor agreement. For them, the law provides for the possibility the collective labor agreement to be applied to them through their accession. Some collective agreements may be granted general effect, i.e., effect regardless of the parties that concluded them. This refers to collective agreements concluded at industry or branch level. Extension of their effect is admissible when they are concluded between all representative employers and trade union organizations at the respective level. The condition for applying the option is a joint request to the part of the parties to the contract. It shall be addressed to the Minister of Labor and Social Policy. The granting of such effect is carried out by unilateral act of the minister. This happens very, very rarely in our country. We had only 2 or 3 such agreements. You may read more about the collective bargaining in Bulgaria in the printed speech of mine. I thank you again very much for the invitation. I am happy to be a speaker together with other women. So now is the women's panel of our conference. And what I would like to say, I'm very happy to meet today in the afternoon Mr. Kukiadis. He was the first Western professor whom I personally met when I was a young assistant professor, and when there were very, very good relations between my faculty, the Faculty of Law in Sofia University, and the Faculty of Law in the University of Thessaloniki. Thank you.
Thank you, Casimira. Thank you for your participation. You've been very enlightening about the procedure and the binding terms of the collective agreements. And now the floor is to Professor Vesna Simovic. Thank you.
It's my great pleasure to be here to present main trends of collective bargaining in Montenegro and to see my old friends from other countries. When I saw agenda, I understood that I have only 10 minutes and I prepare a very short presentation. So you will have more information about collective bargaining in Montenegro when I send my report, and it will be published, as I understood correct. Collective agreements follow laws as the second most relevant source of labor law in Montenegro. According to the labor law, collective agreements can be concluded at 3 levels. There are general collective agreements, only one at the national level, sector-specific collective agreements at the level of a sector, group and subgroup of business activity, and collective agreement with employer at the level of organization. It should be noted here that collective agreements concluded at a certain level apply to all workers at that level of organizing, regardless of whether they are members of representative organization that have entered into such agreements. In addition to that, matters regulated by collective agreements are the same, irrespective of the level of collective bargaining. In accordance with the labor law, the following issues can be regulated by collective agreements. For example, the number of days of annual leave, duration of paid leave, deadlines for payment of salaries, the manner of increasing the salary for overtime work, past work, night work, and work on public holidays, and other grounds of increasing the salary, amount of salary compensation, other incomes of employees, etc. The level at which collective agreements are concluded also defines the scope of agreement itself. This is due to the fact that less satisfied interests, for example, lower level of rights, require a territorially wider level, and vice versa. On the other hand, the higher level of the collective agreements reduce the differences in the labor and social law position of employees, which leads to equalization in business and rights. Collective agreements concluded at the lower level are richer in content, more specific and more favorable for employees. This means that they can provide for a larger scope of rights and conditions that are more favorable for their exercise in relation to collective agreements concluded at a higher level. A collective agreement shall be concluded for a definite period or for indefinite period. A collective agreement concluded for a definite period shall cease to be valid upon the expiration of the period for which it was concluded. However, in accordance with the labor law, the validity of collective agreement concluded for a certain period may be extended based on the agreement of its signatories if the agreement was signed 30 days before the expiration. All collective agreements contain a clause providing for the establishment of a special body for the implementation, monitoring, application, and interpretation of that agreement. For example, committee or commission. This body is formed on a parity basis from an equal number of representatives of each contracting party. The conclusion of collective agreements in Montenegro is basically voluntary, but according to the labor law, the social partners are obliged to negotiate collectively. This obligation of collective bargaining does not always have to result in the conclusion of collective agreements, but it is important because it contributes to improvement of social dialogue. In order to produce legal effect of collective agreement, must be signed by all participants in collective bargaining. It is necessary to point out that in case there are several representative trade unions in certain level of collective bargaining, each of them must be a signatory of the collective agreement. The situation in Montenegro is the same like in Serbia. For example, collective bargaining in private sector is not development enough. So in future in Montenegro, it is necessary to improve bipartite social dialogue, especially in private sector. In this sense, it is necessary to encourage trade union organization in sector where there are no collective agreements, and especially in the trade sector, which employs the largest number of workers in the economy. For example, in this sector, there is no branch level collective agreement, and there is no representative trade union at the branch level, while there are only 10 representative trade unions at the enterprise level. Also, collective agreement must be harmonized with the labor law, especially in the part of the decision that refers to wage, including the collective rights, informing and consulting trade union especially. In order to encourage alternative method of resolving of labor disputes, collective agreements should include clause referring to the peaceful settlement of disputes. Also, collective agreements could regulate the specific of certain branches related to flexible forms of work, such as teleworking, part-time work, fixed-term work, and other, because the new forms of employment are not included in the collective agreement in Montenegro. Thank you.
Thank you very much, Vesna, for giving valuable information in such a short time. And now the floor is to Rana. Ivan.
So can I have my presentation? It will be. May I use this opportunity to thank the organizer for having me, in particular, the Professor Kostas Papadimitriou, for gathering us all together, and especially for showing us this beautiful city, so rich in history. So I would like to present my paper on collective bargaining in Croatia. And in the initial part of my presentation, I quite briefly refer to the recent history of collective bargaining in Croatia. The majority was already told by my colleague, Professor Jašarić, since we have shared the legal history. And then I've explained the relevant statistics, namely the trade union density in Croatia and collective agreement coverage. And then in the central part of my presentation, I focus on legal issues and conclude by emphasizing the main characteristic and the problems. As already mentioned by Professor Jašarić, in the socialist era, there was no collective bargaining both in Serbia as in Croatia, due to the fact that it was considered that there were no conflicting parties, namely the employees were considered to be the owners of the means of work. So the first piece of legislation, which was a legal basis for adoption, collective agreement, came into force in 1996. So one can conclude there has been less than 3 decades of legal history of collective bargaining. As you can see, the trade union scene in Croatia is rather heterogeneous. There is a great number of small trade unions, 630. However, 3 of them are recognized at the national level as representative, namely 3 umbrella associations, trade union associations are considered representative, for instance, to represent them in the ILO conferences. Regarding the novelty, it should be mentioned that we have a rather new trade union of digital workers, although they are not recognized in the Labor Act as employees. However, there is a recent draft on a new Labor Act dealing also with digital workers as potential employees. Regarding trade union density is rather high compared to other post-socialist countries, but please bear in mind the fact that actually trade union density in public sector is very high as opposed to private sector, in particular in small companies, is below 10%. Regarding the coverage of collective agreements, same refers here. The differences is huge between the public sector on the one hand, where it amounts to 88% as opposed to 35% in private sector. Let me explain the national regulatory framework of collective agreements in Croatia. Although it is not expressly stated or recognized as a constitutional right, a right to bargain collectively, it can be derived from another constitutional right, a right to establish trade unions, and the main goal of trade unions is to bargain collectively and to conclude collective agreements. However, collective agreements are mentioned expressly in another provision which states that collective agreement is a means of regulation, social security and social insurance of the employees and their families, which is copied and pasted from French constitution and quite a typical clause of our collective agreements, which are mostly focused on the increase of or improvement of working conditions. Already mentioned Labor Act is the legal basis for conclusion of collective agreements, and all issues related to collective bargaining is regulated by Labor Act, apart from the fact who can be trade union, who can be a party on the side of trade unions when concluding collective agreements. It's regulated by the separate piece of legislation, namely the Act on Representativeness of Employers, Associations and Trade Unions, in which states when the trade unions cannot agree who among them is representative for bargaining, then they approach to a committee for representativeness, which decides who is a representative trade union, and the representative trade union is the one who has at least 20% of members from the total number of unionized employees at the level at which they bargain collectively. Regarding the differences between the role of trade unions on the one side and work councils on the other, there are two separate channels or two different paths of protection of employees. Namely, the main role of work councils is co-decision with employers when making some important decisions, even in particular during the dismissal procedure. And the main role of trade unions is to organize strike and to bargain collectively. However, if the work council is not established within the employer, the shop steward assumes all the rights and obligations of the work council. Regarding the contents of collective agreements, 50% of all currently valid collective agreements regulate the level of the basic wage. 25% of them deal with discrimination prevention, 50% contain provisions on harassment, 75% contain the procedure of dispute settlement regarding collective agreement implementation. Then, according to the Minimum Wage Act, it's the parties to a collective agreement are entitled even to deduct from the statutory defined amount of minimum wage, but no lower than 95% of statutory defined minimum wage. I would like to emphasize, apart from this limit regarding the amount, other limitations are not provided by this act regarding the time limits or the obligation of the contracting party to provide objective justification for such deduction, quite contrary to the proposal for directive on adequate minimum wages is of course still a proposal, but one I hope when it will be adopted, there should be, the national law should be amended and come in line with this proposal directive. In cases of financial crisis of company, there were a few cases of trade unions who actually accepted and agreed suspension of a certain provisions. Let me explain the principle of favor. How does it function in Croatia? So the main goal of collective bargaining is to increase the workers' protection, improve their the working conditions, but there are some provisions expressly stated within different pieces of legislation, such as the Labor Act or Minimum Wage Act, according to which the parties to a collective agreement are entitled to provide for less favorable conditions as opposed to the minimum standards introduced in the legislation. One was already explained by deduction from the statutory defined minimum wage, and there are some other examples regarding the overtime work or other working conditions. Such cases, collective agreements are seen as means of flexibilization of working conditions. Please bear in mind that once collective agreement has been concluded, if not signed by all representative trade unions, it will be applied solely if the representative trade unions signatories have in their membership more than 50% of workers, of total trade union organized workers in the representative trade unions. As already mentioned by some other, in some other national reports, there is so-called erga omnes effect, which means that the collective agreements are applied both for the members of trade unions and for non-unionized employees. This is, of course, strongly criticized by trade unions for free riding. And in the recent legal history in Croatia, there was a provision introduced in the Labor Act, according to which the non-unionized employees had to pay some fee for using the more favorable provisions of collective agreements, but it was abolished by the Constitutional Court as unconstitutional provision. Another issue which I would like to raise is the manner how the collective agreement in time of crisis can be terminated. It's quite unclear whether the employer is allowed unilaterally to cancel, to terminate collective agreement, or to apply rebus sic stantibus clause. And due to the fact that even when the collective agreement has been terminated unilaterally, that it still has to be applied due to the so-called after effect of collective agreements. So another 3 months, it should be and must be applied, although unilaterally terminated in times of crisis. Regarding the settlement of labor disputes, all collective disputes must be settled or try to settle by mediation, the so-called mandatory mediation, unless the conflicting parties agreed on arbitration. There is also a guarantee introduced in the Labor Act on judicial protection of the rights arising from a collective agreement. Let me emphasize the main characteristic of the collective bargaining in Croatia. namely, there is a low trade union density in private sector, in particular among the small companies, which has an effect in their protection of employees employed by small companies. I would like to emphasize the problem of lack of clarity. How can the employer unilaterally terminate collective agreements in times of crisis due to the 3-month after effect of collective agreement? And I would like to emphasize inadequate regulation of deduction of minimum wages by collective agreements, because the Labor Act does not provide for obligation of the contracting party to provide objective justification or time limits for deduction from the amount of statutory defined minimum wage. Thank you.
Thank you, Ivana, for presenting a very solid system, though even this system can be vulnerable to economical crisis. And thank you for proving that women can keep on time more than men. The floor is to the audience. Who wants to pose a question or make an intervention? Madam there.
Yes. My name is Olga Angelopoulou. I'm a mediator at the Greek Mediation and Arbitration Organization. I would like to thank you very much for these highly interesting presentations, which give rise to many thoughts in many ways. But one thing that I found especially interesting is that both for Bulgaria as well as for Croatia, you mentioned that topics and issues that can be regulated by means of collective agreements and issues for collective bargaining are also issues for social insurance, as you mentioned. These are topics that are exclusively excluded from the scope of application of collective agreements in Greece. This has, of course, important historical reasons that both have to do with the economy and the history and the structure of the mandatory social insurance system. Of course, the so-called public social insurance system. It's very difficult to understand how this works differently in another country. Therefore, my question will only be the following. Can you give us some few examples of just some important examples that you find interesting of provisions of collective agreements in your country that regulate the very important topic of social insurance? Thank you very much.
Thank you for your question. It's mostly regarding the private social insurance, namely private health care or occupational pension scheme. So it's additional from the statutory regulated social insurance. This is the case.
Okay, Krasmira, if you want to answer.
Yes, the situation in Bulgaria is almost the same as in Croatia. There are not so many cases when collective labor agreement regulates social insurance problems, but there are examples for regulation of the voluntary pension insurance under an occupational scheme, for supplementary unemployment insurance, etc., but they are not so many.
Thank you. And the next question.
Thank you, the three of you, for your very interesting presentations and the historical insight before you come up to present to all of us the structure and the ideas of your system of collective bargaining. What strikes me, and I will just explain myself, I have functioned in Greece as a mediator and arbitrator for several years at ΟΜΕΔ, and lately I function only as mediator because we have to choose one of the two issues. So, your system of resolving collective disputes has not been clear enough to my mind. I do understand that you have a system of mediation, to which I want to understand if in each of your country, mediation is decided by both the conflicting parties for collective bargaining, or the initiative can be taken by one of the parties. And then, when we go to the level of possible arbitration, how does it function, if it functions? Is it that the arbitration might be activated on the initiative of the one party, or it is necessary that both parties should apply for arbitration? And then I want to understand, in each of every system, do you have an independent body for mediation and arbitration services or not? And also, if mediation incorporates conciliation for collective bargaining or not, or if it is a distinctive step before mediation, and whether conciliation applies also not only to collective disputes that may result or may have as a scope the conclusion of a collective agreement, but also if conciliation applies to individual disputes, that means the implementation of a collective agreement or any other issue that might be raised by one employee or by a group of employees, or if it is necessary that a trade union might take the initiative to ask for conciliation. Thank you very much.
Thank you for your question. So, regarding the system of mediation and arbitration in case of collective labor conflicts. So, mediation is mandatory, is prescribed by the Labor Act. If they fail to do this, the strike will be considered as let's say, not in line with law, and the organizers will be faced with some sanctions. So they must approach to and apply this mediation process. How do they do that? There is a social and economical committee, tripartite body, with a list of potential mediators, and as well there is a list of potential arbitrators. If they decide to try to solve their conflict by arbitration, there must be an agreement. There is no unilateral approach to arbitration. So in case of mediation, it's mandatory. They choose a mediator from the list of social and economic council, and the result of mediation is not obligatory to conflicting parties, which means they can continue with their conflict, which can end up in the strike. However, if they choose the arbitrator to solve their conflict, then the result must be they are obliged by the decision of arbitrator, which means it's considered as a new collective agreement. Regarding conciliation in individual disputes, how is it regulated in Croatia? In case that the employee thinks that some right is breached by his right or her right was breached by the employee, he or she has a 15-day period to approach to the employer, it's mandatory, if he or she failed to do this, he or she is not able anymore to approach to the court and to have a judicial protection. It's highly criticized by some legal scholars, but this is still the way how the individual disputes are solved. So when the employee approached to the employer, and if the employer still thinks that he or she did not breach the law, then there is another 15-day period for the employee to claim the protection before the court.
When you talk about situation in Montenegro, in collective dispute situation, the same like in Croatia. Mediation in collective dispute is obligatory, but result of that is not obligatory for the parties. So when you talk about individual disputes, we have new regulation in labor law that we must have first mediation before the court. It's obligatory too. Result is not obligatory, but the process is.
Krasmira, would you like to answer?
Yes. The situation in Bulgaria is regulated by a special act, namely Settlement of Collective Labor Disputes Act. This act regulates voluntary means for settlement of labor disputes, and also one special instrument, the strike for workers. Bulgarian law doesn't regulate mediation. It regulates bargaining between the parties, then conciliation, and then arbitration. Conciliation is admissible, as I said, only for collective labor disputes. Every party of the collective labor dispute, a group of workers or an employer, may ask for conciliation, and the other party is obliged to accept this procedure. The arbitration may be voluntary and obligatory. The voluntary arbitration is applicable for collective labor disputes when both of the parties of the dispute are asking this. And there is also obligatory arbitration in some specially provided for activities, and namely when the parties of the dispute may not reach an agreement for activities, for the minimum activities during a strike. Conciliation and as well as arbitration may be done by employers organizations, trade unions organizations, and the National Institute for Conciliation and Arbitration. This institute is independent body. This is an agency to the Minister of Labor and Social Policy. But there are very few cases asking for conciliation and voluntary arbitration by the Institute. When there are such cases, mainly trade unions and employers organizations organize this procedure. There is one very simple reason for this. The parties have to pay the costs for conciliation and arbitration by the Institute, and that is why they prefer to ask their organizations.
Thank you, Krasimira. Thank you.
First of all, I would like to thank for these great presentations. I think that it was a great pleasure for all of us to attend. And I have two small questions for the Croatian presentation, which was very interesting, and thank you for that, and very easy to follow as well. So the first one is, it was quite interesting that there is no explicit obligation to negotiate, because in the Greek system this is central, and it is also very important for the mediation and arbitration. So I was wondering what happens if one party does not come to the table of the negotiations, if we do not have an explicit obligation and the one party either does not come to the table of negotiations or negotiates in bad faith. What are the remedies that the other party might have in this case? And the other very interesting point, which I understand that it is an exception from the principle of favor, is the possibility of derogation from the minimum salary. And I see also that there is a cap of 95% of the salary that might be derogated. But you also referred to other cases where you use the term flexibilization, for example, working time or other issues, leaves. And I was wondering whether, even in these cases, we can talk about derogation. So whether a specific type of collective employment agreement might derogate from the national working time legislation, and whether we have some limits there as well, because I think that it is also crucial. And thank you very much again.
Okay, thank you for your questions. I'll start with the second one because it's easier to answer. Regarding the other derogations from in favor laboratories principle, namely, it is explicitly stated either in the Labor Act or in other pieces of legislation in which situation the parties to a collective agreement can derogate from the provisions legislative protection. For instance, in case of regulation of overtime work, the Labor Act states the employees cannot work more than 180 hours a year. However, the parties to a collective agreement can agree on 250 hours of overtime work a year. So there are certain limits provided by, even in cases of derogation. So another case of derogation from the favorability principle is the regulation of protection of agency workers, which is due to the fact of implementation of a relevant directive in this context. So they can be, can have lower level of protection as opposed to the employees employed directly by the user company if there is a collective agreement provided for such regulation. The difficult question on bargaining in good faith. So it states explicitly in the Labor Act that the parties to a collective agreement or those who bargain need to bargain in good faith. But it does not state anything else. It's up to the courts to define what it actually means. So far there is no case law in this regard. So it states explicitly, but the real content of this obligation to bargain in good faith, it's quite unclear. Thank you.
Thank you, Anna. Okay, Mr. Papadimitriou.
Two questions to Ivana. Starting from the past, it's only a question of content of the principle of good faith, or a question of sanctions? That means, is there any sanctions if the court decides that a part has breached this principle of good faith, is there any sanctions or not? Because in Greece it's the same. This is the principle. There is a principle. It's stated by the law, but there are no sanctions. Nobody knows what happens. First that, and second, I don't know if I've well understood. You have cited that if in the company the 50% of people are binded by the agreement is not applied, or the agreement covers all the employees of this level. That means if there are less than 50%, there is no collective agreement. No. Even
it's not no. It's the case how to solve the problem when the signatories to collective agreement are not all representative trade unions. Only a minority of them decided to sign the collective agreement. And it will be applied solely if the majority of membership is included, which means only the trade union signatories who have at least 50% of all unionized employees at this level of bargaining. So it is how to avoid the problem when only the minority of representative trade unions decided to sign a collective agreement. This is regarding regarding the section, as I already answered to your colleague, there is no sanctions provided by the legislation for breach of the bargaining in good faith, and no case law so far in this regard.
I would, if you are kind not to
I didn't say.
No, you have the floor, but please,
no. I just
be brief, because we have
very brief.
Okay, thank you.
When we call sanctions, as Professor Papadimitriou said, we said possibly results that might come out of that, not legal effects. For example, in Greece, it used to be that if you are not cooperating in mediation, then this is something that can be evaluated in case of a strike, or that could give the impetus of applying for arbitration. This is the thing that I would like you to elaborate in this breach of good faith in the negotiation between the parties. Thank you.
So, okay, now it's clear what you want to ask me is, I think that the obligation, mandatory mediation is more formality in a sense that no one checks whether there is a real intent on the side, the one on the other, to solve the problem by mediation. It's more formality than that it's seen as in this context as a material precondition for adequate collective bargaining.
Understood. Thank you very much. We don't have any other question. This is the time when we set you free. Thank you very much, Krasimir, for your collaboration. And in 1 hour. Okay. Thank you.
The last one was a male panel. Now it's a female.
Is it the form of segregation?
Capite? Να σε καλά, ευχαριστούμε πολύ.
I don't know. Ivana, how could you find your PowerPoint?
Γιατί είμαι καλός μαθητής, για πήγαινε.
Okay.
Η αντιπροσωπευτικότητα είναι όλο για να συναντήσει συλλογική σήμερα. Αλλιώς δεν συναντήσει. Δεν κάνω λάθος.
Thank you. Με την Τουρκία έχετε επαφή? Οκ. Fine. Άγγελε, λες να πούμε κάποιος.
Music is the inside, so that's it. I don't know, Kim.
Continue, please, continue. This is part of the social part of the conference. Thank you, Senat.
Welcome.
After the end of the social part of the conference, we have to continue with the reports. Certainly. So, Nikos, take seats, please. Good afternoon. Okay. Good afternoon to all of you. We have via web our professor from Turkey, Kubra Dogan. Thank you for being with us. Due to climate reasons, you cannot be with us, okay? And always Krasimira with us from Bulgaria, the two persons who weren't able to be with us. However, the first person, Luca Tishar, had a problem, a personal problem, and it was a question of accident, so she cannot be with us. Well, okay. So let's hope that all things will be very good for Luca. And we start now with Professor Alexander Rikovsky. He is an associate professor at the Cyril University of Skopje, North Macedonia. So Alexander is going to present us the situation concerning collective bargaining in North Macedonia. Alexander, it's close. The floor is yours. And Alexander speaks very well Greek.
Sure. Rather say tries to speak to improve.
As you want, eh?
Okay, presentation is here. So although it's a little bit difficult to draw audience attention after lunch, particularly, but first of all, I would like to express my gratitude for being here to the Omorphi city of Thessaloniki and to be invited by ΟΜΕΔ and to our precious colleague Kostas, who basically broke the ice in these 2 years while we haven't seen each other face to face in vivo. So a very courageous step towards having us all here and having this splendid conference so far. So thank you once again. I'll try to be as precise as possible and to follow the pattern that was delivered to us beforehand, although there are always two extremes. Us as academics always, have the problem of being pathologically extensive on the one hand. I'll try to, so to say, to present my presentation in the time allotted for this particular occasion. So, historical backgrounds or trends. I'll try to briefly illustrate the historical trends of collective bargaining in North Macedonia as part of the development of the entire system of industrial relations or collective labor relations in the country. And in that sense, there are obvious many commonalities between former communist or socialist countries in the region, but as far as I heard, there are many also commonalities between other southern eastern countries that are represented here. So yes, at the outset of establishing pluralism and market economies in these countries that I mentioned, there was the tremendous, so to say, a situation of decline of trade union membership and density rates, mainly due to several factors, such as, for instance, privatization of formal state-owned or socially owned undertakings, restructuring of socialist era enterprises, growth of the service sector, and so on and so forth. For instance, privatization has affected the decline of trade unions in a number of different ways, more specifically through the emergence of newly established micro and small-sized enterprises, where trade unions fail to expand their networks of coverage, or the growth or simply by the establishment of new private undertakings, trade unions fail to expand their networks. There were also a situation where these countries try to attract a foreign direct investment, which are mainly hostile towards trade union and unionization. This can be seen even nowadays in North Macedonia, where trade union penetration is very low in the companies run by the foreign companies, basically, or have the status of foreign direct investments. After the independence of North Macedonia from the former Yugoslavia, almost all of the aforementioned trends concerning these industrial relations that I just mentioned were present in a way. In any case, the particularities may be divided into two developmental phases. The first phase of the evolution, so to say, of industrial relations or collective labor relations, and in that sense, collective bargaining in North Macedonia, encompasses the period of the introduction of the first labor relations law of 1993 until 2005. And the second phase, which encompasses the introduction of the law of 2005, which is currently in force up to today. Although there have been more than 30 amendments and modifications to the law, there is a work in progress. Basically, there is a working group working on the new law on labor relations, which never appears because the working group is working for more than 4 years now, and it resembles in a way, or it seems to me, like the famous role play Waiting for Godot, who never appears. And this is sometimes used by the social partners to, so to say, to at least feel discouraged to go deeper in collective bargaining or to bargain collectively. But this is what I will speak in a couple of minutes. So as I said, in the first phase, or the phase of from 1993 until 2005, the collective labor relations system was characterized by a lack of regulation. It was regulated basically in a very superficial way. There was no regulation of tripartite social dialogue. There were not adequately governed the establishment and administration of workers and employers organizations, as well as collective bargaining was not regulated thoroughly, so to say. On the side of employers, there was the problem because employers were not able to organize in specialized employers associations aimed at participating in tripartite social dialogue and collective bargaining, because they were instead represented by the economic chamber, and so which required mandatory membership. So this was a thing or an issue which was brought by the ILO supervisory bodies in order to create the necessary legislative infrastructure in order to prepare, so to say, the conditions for establishing and for organizing employers' organizations at the appropriate level for the appropriate aim. The second stage, taking into consideration what I mentioned before, that it lasts for more than 15 years, I tried to subdivide in a way into sub-phases. The first phase, which encompasses a period from 2005 until 2009, where important major amendments to the law were introduced concerning representativeness of employers associations and trade unions, and the second subphase where I will speak about the trends, the current issues, and the issues to come in the near perspective. So taking into consideration this first subphase, this was characterized by improving some of the shortcomings from the previous period, from 1993 up until 2005, where a procedure for establishing registration and establishing and obtaining legal personality status of trade unions and employers associations was introduced, as well as this is the period where the first criteria for and conditions for obtaining representativeness of social partners were introduced, although not in a sufficiently clear and comprehensive manner. As you can see, the criteria and conditions for the representativeness threshold for engaging in collective bargaining was set at 33%, which, taking into consideration the situation that workers and employers organizations were in a way of a post-transition agony, it appeared to be a very high representativeness threshold, which eventually did not lead to establishing pluralism in the relationships between trade unions and employers, and to open the gates for establishing multiple confederations on the side of the trade unions particularly. So this situation was in a way improved by the amendments to the law of 2009, which revised the criteria and conditions for representativeness. These are currently in force. We have there are 4 levels of representativeness in North Macedonia's collective labor relations system. The first one, or the highest one, is aimed at tripartite social dialogue. And on the basis of that, trade union confederations and employers associations are represented in the Economic and Social Council of North Macedonia, while the remaining 3 levels of representativeness are aimed at collective bargaining at different levels. For instance, the first level is aimed at collective bargaining at the national level for the purpose of concluding general collective agreements for the private and the public sector. The middle level is aimed at collective bargaining in order to conclude the branch level, that is section level, according to the National Classification of Activities, collective agreements, and the lowest level is the level of a company. So here you can see that the representativeness thresholds have been lowered once again, and there are 10% representativeness threshold for becoming representative as a confederation on the side of the trade unions. That means that at least 10% of the total number of employees should form part of a confederation in order for that confederation to be representative at a national level and to be represented in the Economic and Social Council. While on the side of the employers, the representativeness threshold is set at 5%, meaning that at least 5% of the total number of employers should be members of the employers association established at a national level, or the employers that are members to the employer association should, so to say, should employ at least 5% of the total number of employees in the private sector in the country. The other levels of representativeness are fixed at 20% on the side of the trade unions and 10% on the side of the employers associations. Very briefly, just in order to show how and whether these new improved criteria led to more pluralism. In a way they did, because more confederations were established, let's say at national level, that eventually appeared to be representative, although at the moment only the Federation of Trade Unions of Macedonia, or SSM, is representative at a national level. And on the side of the employers, we have the Organization of Employers. But as you can see, the representativeness at private sector, for instance, and when we try to compare it with the case in Greece, in other countries in the region, we can already see that collective bargaining in the private sector and the strength of the, so to say, trade unions in the private sector are in a way less powerful compared to public sector collective bargaining and the situation concerning the private sector. Concerning trade union density, you can see the data here. So trade union density at a national level is estimated at 17.29% for 2020, which is below the EU average. The last data that I checked was around 23%, so this is below that anyway. Concerning the collective bargaining coverage, it depends on the level of collective bargaining and how you, so to say, qualify, how you treat the collective bargaining. If we take into consideration the general collective agreements, which are concluded at the national level, having an erga omnes effect, then you have 100% coverage of the employees and employers in a way in the private and the public sector. But concerning collective bargaining coverage in different branches, it is very difficult to come out with data because the law is vague and ambiguous in that sense. It is not clear whether a branch level collective agreements apply to non-unionized workers. So in practice, as I will speak later on, it is treated that yes, branch level collective agreements are covering even non-unionized workers or employees once the employers that are employed by them are members of the employers association that is a party to the branch collective agreement. Although in the last several years there were significant improvements in terms of functioning of the tripartite social dialogue in the Economic and Social Council, such improvements have not been reflected in collective bargaining, primarily in the private sector. Since 2016, we haven't witnessed in a way any conclusion of a new collective agreement at the national or a branch level. Neither the existing collective agreements have been extended or modified. So you see sort of a black hole, a moratorium in terms of collective bargaining in the private sector. One of the reasons, okay, I could name at least 3 or 4 reasons for that, of course, that you cannot, so to say, exempt the bargaining parties themselves for being maybe lethargic in one side or have a lack of, say, willingness, but you know, it's always difficult to reach an agreement or a consensus for certain or particular issues, but also they keep mentioning or repeating that they wait for the new law to come. So once the new law comes, the Pandora box is opened, and we're expecting, let's say, a flow of new collective agreements. But that's for sure not the case. The indifference in the approach of collective bargaining is sometimes even a result of the fact that many of the collective agreements concluded at the branch level, particularly, are of an indefinite duration of time, or they have this automatic extension or ultra-activity clauses, which in a way it could be said that sometimes it had deterrent effect on the dynamics of collective bargaining in the country. Compared to the private sector, as I said, we've been witnessing a better dynamics in the public sector since these last 5 years. Several branch level specific collective agreements in the public sector have been concluded, although the collective agreements at the national level, the general collective agreement for the public sector, hasn't been renegotiated, or so to say, it hasn't been concluded a new national level collective agreement for the public sector since 2008. Speaking about the trends, when I speak about the trends, I with one eye, I have the situation, it's what will apparently come in the near future. Since these are the most hotly debated issues in terms of collective bargaining in North Macedonia, taking into consideration what the new law should cover. For instance, we are expecting the structural levels of organizing workers and employers to be regulated. At the moment, there is a definition of what is trade union, but there aren't criteria or conditions, for instance, how many workers could establish a trade union or an employer's organization, or for instance, what are the levels and the outline of the structure of trade union organizations and organizing in the country in terms of trade union organizations at the grassroots or at an employer level, than at higher levels, meaning federations and confederations. In terms of the legal personality status or the legal subjectivity of trade unions, this is also very hotly debated issue in a way in North Macedonia. Why? Because in 2012, there were amendments to the labor relations law where the legal subjectivity of trade union organizations established at an employer level was abolished. These, so to say, amendments were triggered or were initiated by federations and confederations represented at higher level in order to strengthen their organizational but also financial capacities. So currently, a trade union organization at an employer level can function only within and as part of a higher level trade union and federation or confederation. And there are situations where, for instance, workers, although have the will and have the possibility, the will, it's better to say, to organize themselves at the company level, but without choosing to register themselves through a higher level trade unions, it is not possible to do that. This situation seriously, in a way, impedes freedom of association and organization and collective bargaining, and is such considered to be, in a way, contrary to the ILO Convention number 87, and as such it is noted in the ILO Technical Memorandum for the new draft labor relations law in North Macedonia. Of course, there are also different issues that are debated, such as, for instance, the idea for clarifying the functional and personal scope of application of collective agreements, then the issue regarding the extension of the branch collective agreements in order to have erga omnes effect for the entire branch. The issues concerning duration, continuation, and cancellation of collective agreements will be improved in a way in the new law. I also, following the pattern, wrote down under a question mark, this relationship between citizens versus workers. By that, I mean, I have in mind a situation where, for instance, the Constitution of North Macedonia, under Article 37, states that citizens have the right to form trade unions. But if you try to translate that provision into the labor relations law, you will see that the law, of course, operates with the term workers, which in terms of North Macedonia's labor law is understood very narrowly. So workers are employees in the narrowest sense, meaning that in order to be qualified employee, you need to enter into an employment relationship, but by concluding an employment contract, which is treated as a formal act. So this kind of, regulation, without at the same time having presumptions for the determination of the existence of employment relationship or other presumptions that could open, so to say, the understanding and the qualification of workers, in a way excludes many workers from their constitutional right, at least in practice, to form and join trade unions. Such workers are workers with civil law contracts, mainly falsely self-employed. And to tell you a curiosity, or maybe it won't be a curiosity because maybe you already face this kind of situation in your countries, the public sector is one of the biggest, so to say, abusers of civil law contracts, handing these kind of, false contracts to many employees, notional at least, in the public sector. So also excluded are informal workers, casual workers, and self-employed, including freelancers. Now, the link between trade unions, or link between collective bargaining versus employees' participation, or as I'd rather speak about the link between trade unions representatives and workers' representatives, as they are regulated in the context of North Macedonia's labor law, or elected representatives of workers. Here, the situation is also very blurred in a way. Although the 2010 amendments to the law introduced a general legal regime for information and consultation of workers and the special legal regimes for information and consultation in the events of collective bargaining, in collective redundancies and transfer of undertakings, this was made in a way to at least formally harmonize the national legislation with the EU directives. But in practice, what's happening is that we do not have a substantial definition of the term worker representative for the purpose of information and consultation, nor we have procedures for electing such representatives. Neither their competencies are distinguished from the competencies of trade unions and trade union representatives. So in a way, having these workers' representatives inserted in the law makes many employers in many situations to okay, so I'd better say that trade unions are hostile to workers' representatives because in many ways employers abuse or misuse their status compared to trade unions, and it leads sometimes trade unionists and trade unions to dub workers' representatives as Trojan horses within the national legislation. Of course, the difference is obvious because you know, best in Greece in this this mythological tale that the Trojan horse entered the gates of Troy and stayed only one day or one night there. But these workers' representatives are present in the North Macedonia's labor legislation for more than 10 years. And the situation hasn't been improved, and this participation of workers hasn't been systematically regulated. Okay, so speaking about collective bargaining issues, the subject matter of collective bargaining in North Macedonia is usually encompassed into three groups of issues, issue concerning working and employment conditions, such as wages, working hours, holiday leaves, and so on and so forth. Relationships between employers and workers, such as issues concerning information and consultation of workers, procedures for protection of individual employment rights of workers when they're breached by the employers. And the third group of questions are the question or the issue relating the relationships between employers and their organizations and trade unions that could be both of obligatory nature, meaning you know, amendments and changes to the collective agreement, interpretation, and so on and so forth, but could also be from so-called collective normative nature, when issues such as protection against anti-union discrimination or support of trade union activities are regulated. Concerning the contents, most of the collective agreements are copying each other's. This is sort to say a situation that I have already noticed in other countries. Collective bargaining generally comes down to issues that the law sets out in the form of minimum standards, or the law directly, in a way explicitly, refers to regulating certain or particular issues by collective agreements. On rare occasions, collective agreements regulate certain issues that are not stipulated or directly arise from the law, and as such have the status of primary legal norms. For instance, such an issue was the issue of annual leave allowance, which was regulated by the collective agreement in the private sector without it being regulated by the labor law. Undoubtedly, the main issue for collective bargaining in North Macedonia is the issue of wages, as I said, but speaking about the national minimum wage, it is regulated by a law and not by collective bargaining. In the past 10 years, the national minimum net wage has soared more than 100%, from 130 euros as it was in 2012 to 292 euros as it will be starting in April 2022. However, the problem is that the soaring of, as I said, more than 100% of the national minimum wage has not been mirrored or translated to other wages, other base wages in North Macedonia. It didn't have the effect of symmetrical or spiral increase in other wages by collective agreements. So there are situations, for instance, where you know, a lowest paid employees, cleaning staff, earn, for instance, the same base salaries compared to 5 years length of service nurse. The reason for that is, to a certain extent, can be attributed to the fact that the collectively negotiated lowest sectoral wages that have the effects of, you know, regulating higher wages, base wages, regulated by collective agreements, are still set at a lower level compared to the national minimum wage. If we try to speak about new or innovative contents in the collective agreements in North Macedonia, we won't find anything such as, for instance, forms of flexible working time or work-family balance policies oriented towards the needs of workers, or as we heard in the case of Croatia, for instance, provisions regulating prevention and protection against harassment and sexual harassment. And we will neither see or witness telework, for instance. Why I mentioned telework or teleworking, I mention it particularly because during these 2 years of pandemics, more than 15% of the employers in the private sector in North Macedonia use teleworking as a way of organizing their working processes, but neither the labor relations law nor the collective agreement, meaning the general collective agreement for the private sector, although negotiation was started, social partners or bargaining parties were stuck in the issues concerning the organization of working time and the liabilities of the employers concerning occupational safety and health concerning telework. The levels of collective bargaining, okay, as I said, we have 3 levels of collective bargaining. Collective agreements are concluded at a national level, at a branch, that is section level, at the level of employer. The system of collective bargaining is based on a vertical, sectoral, industrial-based approach, so to say, because in North Macedonia there isn't collective bargaining, for instance, for a particular area, the territory, municipality, region. Neither the industrial relations system recognizes occupational collective bargaining agreements, although in practice there are 2 or 3 sectoral or specific branch collective agreements that resemble occupational collective agreements. There are some dilemmas, and I will speak about the dilemmas concerning the collective bargaining at national level. Although at first glance it seems that the law clearly makes a distinction between the functional scope of private and public sectors. In practice, there are several borderline activities where it is problematic or debatable, at least, which one of the 2 general collective agreements will be applicable. This is so because in one of the provisions, the labor relations law puts the legal entities performing activities of public interest, meaning kindergartens, schools, universities, in the context of the functional scope of collective bargaining in the public sector. But at the same time, there are private institutions such as private kindergartens, private nursing homes, private universities that do not bind or cannot be subsumed under this functional scope of collective bargaining in the public sector. So this is, so to say, problematic issue in a way. in terms when there are no additional criteria for differentiating between public and private sector. Another open issue, for instance, is the issue of which of the general collective agreements, the private or the public, in the public sector, would apply, for instance, to independent performers of activities of public interest, such as notary public or enforcers, and so on and so forth. Application of collective agreements. Okay. General collective agreements, or those concluded at a national level, and individual collective agreements, as collective agreements concluded at a company level, apply to all the sides involved and all the persons involved, so they have erga omnes effect. The only problem, so to say, lies in specific collective agreements, which have limited scope of applicability. They obligate the parties, trade unions and employers associations that sign them, and the parties, trade unions and employers associations that additionally access to them, while they apply to persons such as employees and employers, members of the parties obligated by the collective agreements. There are practical dilemmas that derive from this kind of model. For instance, it is quite unknown, or it is disputed, or it is, so to say, interesting and important to be resolved in the next law. The question, what are manners and conditions for acceding to a concluded collective agreement at the branch level? Because as I said, it is considered that there could be only one collective bargaining agreement at one unit. So trade unions or employers associations that are not signatories to the concluded collective agreement, there are not clear rules. How can they accede to these concluded collective agreements? The other issue is the issue of, will the collective agreements binding a certain employer apply to non-unionized workers or non-members employed with that employer? In practice, employers usually apply the normative parts, such as working conditions and terms of employment of a valid specific or branch collective agreement, to employees who are not union members. This kind of situation is a result of the implicit application of the constitutional and statutory provisions which prohibit discrimination on any grounds, including membership or non-membership in a trade union. And since I suppose I have crossed over my time, maybe, I will finish my presentation with some, so to say, information concerning the favorability principle. Okay, the principle of favorability in the labor relations in North Macedonia is recognized by the law, although I would say in a partial way, because the law, so to say, grants or puts the favorability principle only in the context of employment contracts and collective agreements in their relation to the law. But, you know, the relationship between lower level and higher level collective agreements is not covered in a way, but in practice it is treated that all the lower labor law sources need to have more, so to say, improved or greater rights and more favorable working conditions to higher level legal sources. Concerning the hierarchy of labor law sources, the highest legal act which stipulates or refers to the labor law sources in North Macedonia is the Constitution. The Constitution states that the rights of employees and their position are regulated by law and collective agreements. But this provision is further not comprehensively regulated by the labor relations law itself. On one hand, so to say, the status of employers' internal acts are not known. The law mentions the internal acts of employers, but they are neither properly defined nor their position is adequately determined in relation to other labor law sources, taking into consideration the favorability principle, nor their subject matter or scope is at least indicatively regulated, and neither so to say, workers' representatives or trade union representatives are involved in the process of information and consultation for the purpose of adopting these unilateral employers acts. Interesting is that taking into consideration this constitutional provision where laws and collective agreements are sources that regulate labor relations, it leads particular, corners or among social partners, particularly trade unions, to conclude in a way that collective agreements are on the equal footing of laws, which is of course not true and not correct. And at the same time, there is no, an authoritative constitutional or Supreme Court provision. But of course, that collective agreements must not be contrary to the law. And what I'd like to say is that in practice, collective agreements cannot be contrary to absolutely imperative and relatively imperative provisions set out in the law. But the problem in practice appears concerning these relative imperative norms when the law sets the lowest and highest limits for exercising particular rights. And it does that in a very ambiguous and restrictive manner. For instance, the annual leave is regulated with its maximum of 26 working days. I'm speaking about what the law regulates or what the law states about the duration of the annual leave. And it creates problems into practice because collective bargaining parties do not know whether they should contradict this relatively imperative norm or not, although it's more favorable to workers in a way. I will stop here. And of course, if you have any questions and comments, I would be glad to address them in the Q&A part of today's conference. Thank you very much.
Really, you have described all the trends of actual bargaining and the different stages from the socialist past. And now the floor is to Professor Kubra Dogan Yenisey from Istanbul. Thank you for being with us. Professor Yenisey is professor at BG University of Istanbul and is a member of the Council of Administration of the Turkish Society of Labor Law, isn't it? We're here to hear your presentation. Thank you for being with us. You have the floor, please.
Thank you very much. Kalispera to all. First of all, I would like to thank you, Professor Papadimitriou, for inviting me to this conference dedicated to the 13th anniversary of the Organization for Mediation and Arbitration. And I'm truly sorry that I missed such a great opportunity to be with you in beautiful Thessaloniki. Istanbul is under a heavy snow, which is not expected at this time of the year. So it's a great honor and pleasure, at least, to reach you via Zoom. Thank you very much. And now let me share with you my PowerPoint. Okay, I think it's done. Now, in my part, I would like to tell you about recent trends. First of all, I will talk about historical framework of collective bargaining in Turkey, and then I will talk about the structure and deadlocks of the model, and if I may say that, new trends in order to explain you how things are working in Turkey. So, to start with, even though in the first constitution of Turkey of 1924, we had a specific provision related to the freedom of association, I may say that the Constitution of 1961 is the first one in which we had recognized the freedom of association, the freedom of collective bargaining, and right to strike as we understood it today. Why, if you ask me, what are the legal and sociological reasons behind this development? I should mention maybe first of all impact of ILO conventions and recommendations, and secondly, I should cite the emerging belief in the society that these rights are indispensable components of pluralistic democracy, and also I should refer to the gradual growth of left-wing ideologies in the society. Then there's a period between 1960s and 1980s. It's a period of flourishment for trade union rights in Turkey. There was about trade union density was about 40% or more, but after the military intervention in 1980, the legislator considered that these rights, these collective labor rights, were too much. Trade unions were not mature enough to use these freedoms in a sense of responsibility. So the Constitution of 1982 recognized these rights with lots of restrictions. Many of these restrictions were removed over the time, but that was the main approach of the Constitution as well as the legislator after that period. So under our current act, in our Constitution, the freedom of trade union is recognized for both employees and solo self-employed people. So those who are working with a civil law contract, they could also enjoy from the freedom of trade union, but public officers, they were granted with the freedom of trade union only in 2001. On the other hand, the right to collective bargaining is only granted to employees and public officers. So when we are talking about dependent, economically dependent person, they don't have any right to collective bargaining under Turkish law. And when we come to the right to strike, it is only for employees. I should maybe underline that there's no constitutional recognition of the participation of employees' rights. So it's like North Macedonia, we have workers' representation rules for information and consultation in terms of the collective dismissals, in terms of the health and security measures. But when it comes to the work councils, they have neither legislative requirement nor a practical application in practice in Turkey. So the main representation model is the trade union in the enterprises. So when we look into this development, I may say that this development shows us it's not a self-evaluated but a paternalistic development. So these new rights were granted. These new rights in the Western countries, many of the workers had striven for almost a century. These rights are granted from above. So the state recognized all these rights. And our latest legislative pieces adopted in 2012, but since it didn't bring any structural reform, I would like to talk about the general structure of the system. So main features of this Turkish model after 1980, it is industrial unionism, decentralized collective bargaining, a pluralist model established by the mandatory rules of law. So we have very detailed rules like Greece, as far as I understood, which regulates all parts of the industrial relationship. So first of all, industrial unionism, if I should mention that, under Turkish law, only industrial level unions could be established. The legislature of 1982 aimed to create a neat and centralized union model to originate powerful unions. The sole organizational principle is national industrial unionism, so workplace and craft unionism is not permitted, which is not in compliance with the ILO conventions. So this compulsory industry unionism resulted in considerable reduction in the number of trade unions in the country. It's a model of pluralism in the sense that employees and employers are free to form different unions in the same branch of industry. I should underline that one of the characteristics of the Turkish unionism is the rivalry unionism. More than 90% of trade unions are affiliated with three big confederations, Turkish, Disk, Hakish, in accordance with their political views. So left wing, right wing, and central. So deep political division among confederations pass through to unions in the same industry. And industries, there exist 20 industries in which unions could be established, and these industries are also determined by law. Secondly, decentralized structure, the compulsory bargaining level is the workplace. So very much decentralized. During the 1960s, Turkey has a multi-level bargaining model, industry level and company level, and country is shifted from quasi multi-level bargaining model to one-level bargaining in 1982 again, due to complexities arising from multi-level collective bargaining model. Although Turkish labor law is very much influenced by Swiss and German labor law, when it comes to the collective bargaining structure, it is shaped up in the North American bargaining model. So very much decentralized. We have three types of collective agreements: workplace collective agreements, enterprise collective agreements, and group collective agreements. When it comes to workplace collective agreements, it is really the factory level, the minimum bargaining unit. But if an undertaking, if a company has more than one workplace in the same branch of activity, so if you have three different factories in the same branch of the activity, then it could be established an enterprise collective agreement. There is a slight difference between enterprise and company level, but enterprise collective agreement covers all workplaces at the same industry. And if the labor union could be organized, could organize workers in different companies at the same level of at the same industry. So different employers association, union, and labor union, they can come together and conclude a group collective agreement. The group collective agreement compensates the need for the industry-wide collective agreement under Turkish law. I should cite the group agreement in the metal sector is the very first one, which has a wide scope of application. So when we come to the competence recognition of the competent trade union procedure, it's always the first step. It takes very long time under Turkish practice. The first step is to relate workplace and branch of activity. So it's always a matter of discussion to decide workplace is located in which industry. And then there's a second step that which is related to the recognition of the competence of the union. as my colleague from North Macedonia told that, we have also two preconditions to recognize the competence of a labor union for a collective agreement. First, trade union must have as members a minimum of 1% of workers, employees, engaged in the industry where the union is active. It was before 2012, it was 10% of employees. The threshold was 10%, and it was quite hard for trade unions to pass this threshold. Now, with a legislative amendment, it's reduced to 1%. But I should say, and Turkey was criticized repeatedly by the Committee of Experts of ILO, so there was an amendment. But I should say that since industry now also trade unions have certain difficulties in meeting with this condition. Secondly, if there's a workplace agreement, the trade union should also represent members more than half of the workers in the workplace. So the trade union should have the majority at the workplace. If we are talking about an enterprise agreement, the trade union should have more than 40% of the employees as members working in that enterprise. And then there's a third step. Since it is such a detailed competency system, it requires an institution to determine whether the preconditions are satisfied. It should be noted that the Minister of Labor and Social Security, it has no right to determine the competent labor union, but if the competence of a trade union is challenged, that's often the case. It is up to the labor courts to resolve the dispute and to determine whether labor trade union meets the rules. When we come to the negotiation and mediation, as I mentioned before, there's a very much detailed rules which regulate the negotiation and bargaining procedure. But I would like to focus on the mediation. If the parties fail to come to an agreement over the period of 60 days, then the mediation process starts up. The mediation process is followed by the competent labor authority. The parties to the dispute, they may agree on a mediator name whose name is among a list, official list. So the parties, they don't have authority to choose a name out of this official list. If they don't agree upon a name, then the competent labor authority assign a mediator. The term of duty of the mediator is 15 days, starting from the notification. The system, it seems to me, quite similar to the one in Croatia. The parties may extend this term for a maximum of 6 working days. And at the end of these days, the mediator shall make every effort to bring about a settlement between the parties. The parties are obliged to submit all kinds of information and documents to the mediator. He or she can make some proposals, but if the parties fail to come to an agreement at the end of this time limit, the mediator shall submit his report and proposals, and then the procedure for strike and lockout starts. When parties conclude with a collective agreements has an ergonomous effect, direct and automatic effect over the employment contracts. Since we don't have multi-level bargaining level system, so the only possible conflict is between collective agreement and employment contract, and the principle of favor regulates all of these issues. I should say that whether it's possible to derogate the mandatory rules of the Act, Labor Act should explicitly authorize parties for a derogation which is not in favor of the employee. So we have only 2 trial periods, balancing periods in terms of derogations, but otherwise the principle of favor is the main principle, I should say that. So what are the, if you ask me, main issues? As you all mentioned, wage and wage supplements. We have a general law which regulates minimum salary. So in collective agreements, we can see minimum salary for the company level, which is above the national level. Working times, paid leaves, health and safety measures, disciplinary measures are the most common issues that we see in collective agreements. So I would like to say that after 40 years, we started with the single employer bargaining model. After 40 years, I think I'm a bit late to do that, but now I think you can see better what we got in Turkey. So we see a decreasing union density and collective agreement coverage. When it comes to the trade union density, according to the 2020 January statistics, trade union density is about 14.38%. And when it comes to the collective agreement coverage, it is less than, because since the main bargaining unit is the workplace, the coverage of collective agreement is not more extensive than the unionization rate in Turkey. Just like in the US or UK, Turkish unions must organize workplace by workplace in large collective bargaining coverage. So we have a less collective agreement coverage, and collective agreement coverage in private sector is 5.8% according to a statistic of the 2020. So if you compare the period between 1980s and 2015 and compare Turkey with the OECD countries, you can see that a rapid decline in trade unionization rate. There exist many reasons behind such a phenomenon: privatizations of the big state companies, neoliberal policies, and also maybe this single employer bargaining model, because I should say that such a single employer bargaining model creates strong incentives to pursue anti-union policies, which would not be the case in the case of the multi-employer bargaining model. In certain countries with industrial collective agreements, there is a default wage structure. However, as in the USA, the alternative to the negotiated wage setting is the non-unionized market in Turkey. So there is no need to explain why employers strongly resist unionization in a country. So it's another chart. You can see that dark gray are the trade union density, and light gray parts are the collective bargaining coverage. Unfortunately, I could only find the data for 2017. So there's a slight movement towards upwards in the last years. That's because of in 2017, 1/5 of all public employees were subcontracted, and by a decree, these subcontracted workers in the public sector were given the right to become permanent employees of the public sector. Then they became also unionized. This may be the reason which explains the slight increase in the unionization rate after 2017. In terms of the industries, at the top you see general affairs, it means municipalities, and then defense and security sector, and banking, finance, and insurance. You can see that these industries with they are coming from the they have a greater share of public workers and public sector subcontracted workers. Then it comes energy and cement sectors and hunting and agriculture. The industry with the greatest union density and highest private sector membership is the metal industry, which has this big group agreement, and that includes also manufacturing of consumer durables and automobiles. When it comes to the success of our mediation, the parties consider the mediation process as a legislative burden to overcome before the strike. A recent research points out that in a more than 50% of cases, the parties of the collective dispute settlement meet only once during the mediation period. That proves also that how parties consider mediation. I should also add that in Turkish industrial relations system has a conflict-based nature without a tradition of social dialogue. Therefore, the success rate of mediation is low. And also, I believe that it's also seen in the research that the fact that the bargaining parties have limited powers on the mediation process, such as determining the name of the mediator, the time limits, procedures, this also prevents mediations from being effective. Interestingly, the success rate of mediation on the group level, particularly in the metal sector, is higher than the enterprise level again. And also this system, so you can see the number of mediations in Turkey. Red bars are those concluded with a settlement, very small. Green bars, those concluded with disagreements. So purple bars are total disputes. So you see that the settlement rate is very low in this system. Another result is we have a narrowing agenda for bargaining. Even if unions are established at the industry level, they don't have legal tools to regulate working conditions on the upper levels. So lack of binding devices to regulate working conditions in the industrial level, they focus on the company level and mainly wage issues. So issues such as migration, young employees, or old employees, these issues, they don't find place in collective agreements. And maybe it comes to your mind, decentralization is assumed to bring flexibility to companies in times of crisis. However, the experience of Turkey doesn't confirm this assumption. There are probably other factors than bargaining level which induce such a result. But I should say that under Turkish practice, power relations at the company level is very important. It may be expected that unions lose their bargaining power because of the decrease in the union density. Nevertheless, we should keep in mind that trade unions have the majority in the workplace, so they are quite strong on the bargaining table, and they are not very keen on about these flexibility issues. And I should also again one more time refer to the union rivalry. So it is very important that there's a strong position among confederations, and this rivalry also makes it extremely difficult to use the legal extension mechanism. There exists a legal extension mechanism of the collective agreement, but it's very difficult to use it in Turkey. And I should say that unions have a rigid attitude towards flexibility. Since from the beginning, they try to avoid. Also, they try to avoid their members go for rival unions, refrain from such derogations. We can say that both union rivalry and flexibility perception of social partners are not related to the level of collective bargaining. However, I should say that one level single employer bargaining model with a majority condition in small bargaining units leads union to concentrate on the welfare of their members in the workplace. If a union rivalry intrinsic in the system, unions adopt more upward wage policies and more rigid attitude towards flexible working times. At least that's the Turkish experience. So a recent trend, I should say, that a slight move towards centralization. In 2020, for the very first time, a framework agreement was inserted to the legislation. So the social partners, they have right to agree on vocational training, health and security, employment policies, social responsibilities. So these agreements are not binding, but at the same time, they have a legal tool to regulate working conditions on the upper levels. And in 2017, also a framework agreement for public collective agreements was introduced into the system. So according to this new, government, public employers unions, workers' trade unions, and confederations, they can come together and make a framework agreement. The binding nature of this agreement could be is a matter of discussion in respect of collective autonomy, but I should say that that's the tool which enabled many employees to enjoy collective bargaining coverage in Turkey. So thank you very much for your patience.
Dear colleague, thank you for participating. Thank you for a clear presentation. I underline the low level of coverage from collective bargainings, but however, always there is a hope to develop this coverage and to have more and more employees covered by the collective bargaining. And last but not least, Raluca Dimitriou. Raluca is a professor at the Academia for Economic Studies of Bucharest. She's a member of the Labor Law Network. She's a well-known professor of labor law. Thank you, Raluca. You have the floor.
Okay, thank you very much, and thank you very much to the organizers for inviting me here. I'm very happy to be here and to be able to listen so interesting presentations for all the countries in the region. It was a great idea, and I'm very grateful for bringing us together all. My presentation will be related to some issues related to collective bargaining in Romania, because even though we do face the same challenges as other countries in the region, there is something specific to Romania, and I'm going to focus on that specificity because other than all the problems and the decrease in covering of collective agreements that can be found everywhere in the region, it is something that happens in Romania in particular. First of all, when it comes to collective bargaining, we do have some of a history in the sense that the first piece of legislation adopted in this area was adopted in 1929. And there was collective bargaining in Romania until, of course, the communist period, which was a period of suspension, completely suspension of any type of free social dialogue. We didn't have employers' organizations and not really trade unions as well, because even though formally they existed, they couldn't actually do their job in a free way. So after the 1990s, things have changed, and we had some different pieces of legislation regulated social dialogue, regulated collective bargaining, which is in fact a part of our constitution. Our constitution says that any person can exercise their right to free association and can be subject of collective bargaining. There were some provisions in legislation in 1990s, and things appeared to become quite normal. Let's say that we started to have some important trade unions, not only in public sector, but also in private sector. But something happened in 2011. A new law on social dialogue has been adopted. It's ironically called the Law on Social Dialogue because it wasn't adopted as a result of social dialogue, and it does nothing in order to improve or encourage social dialogue in Romania. In fact, it does exactly the opposite. This law on social dialogue provides that in order to have a trade union, to establish a trade union, you need to have a minimum 15 members, all of them employees, from the same company. So you cannot organize a trade union with colleagues from other companies, and this in a country where most of the companies are small and very small. Like, it is very easy to work in a company with only 3 or 4 or 5 or 10 employees. So in this case, we can say that this type of workers working for very small companies cannot actually exercise the constitutional right to organize in trade unions. The law from 2011 says also that in order to represent your members as a trade union in the collective bargain at the level of company, of a unit, you need to have as members, at least in order to be representative, you need to have as members at least half plus 1 of the total number of employees in the company, which is really something difficult to attain. The previous piece of legislation only said 1/3. And then from this law from 2011, higher condition for representativity has been established. Somehow opposing the view of International Labor Organization, almost no role for non-representative trade unions, who actually cannot do anything into the company. So as long as there is a representative one, they cannot actually accede to the collective bargaining in that company. But even if there is no representative trade union, they cannot do anything because the law encourages collective bargaining conducted by non-unionized employees representatives. So people, workers who are not unionized cannot, of course, vote for their own representative, which can be acceptable as a last resort, as long as there is nothing, no trade union, any other possibility of organization. But it's not what the law says currently in Romania, but in fact, these employees, representatives have much more power than the non-representative trade unions, because they
are the ones who are called to negotiate, to be involved in the collective bargaining, and not the non-representative trade unions. Another thing that the law creates is that starting from 2011, we no longer have a collective agreement at the national level. We used to have, the last one ended in 2010, and now not only we don't have a collective agreement, but it's not possible legally today to negotiate at the national level. And of course, there is no legal possibility of going to strike, except in this very narrow window of collective bargaining. So once the period of collective bargaining is over, you cannot go to strike anymore. If you have a collective agreement, it's not possible to go to strike. For any other reason that disagreement during the collective bargaining, it's not possible to go to a legal strike. So what do you think? Do you think this piece of legislation would produce some effects on the unionization and the rate of membership in trade unions? Well, let's see. This is the rate before of union membership before of the law on social dialogue. I don't have it wasn't already published the last numbers for 2020. But these are the numbers for the previous years, and I would expect that the numbers for 2020 and for now 2022 to be somehow the same, because indeed it was a very dramatic drop in the rate of union membership after the entering into force of this piece of legislation. When it comes to collective bargaining, there are 3 levels where legally the collective bargaining can take place. In Romania, as I said, no more the national level. We only have the level of company, which would lead, in case of success, to a collective agreement erga omnes applicable. The group of companies without an erga omnes applicability, only for those who are actually represented into this collective agreement, and the sector level. In Romanian, sector levels are not exactly the same thing as branch level. Sector levels are many, and they're approved to a governmental decision, and there was an entire debate on the way the sector are decided, because depending on which is the sector, you will have or not representativity as a trade union. There are some conditions, of course, in order to obtain representativity. So you can tailor the sector in such a way that the existing trade union doesn't have any more representativity. So this is why it is important to have this sector. Well, why it was important? Because currently it doesn't matter anymore because we don't have any collective agreement at the sector level at all. So we don't have in Romania the national collective agreement, nor even a sectoral collective agreement. We have some at the group of companies, some collective agreements in budgetary, in public sector, and some collective agreements at the level of company. At the level of company, as I said, we may have a representative trade union, which will be the other party of this negotiation, and that's okay, but still it's not easy to obtain representativity. Otherwise, the non-representative trade union will not negotiate by itself, but together with the employees' representatives. And in most of the cases, in 90% of the cases, the ones who are actually representing the workers are non-unionized employees representative. And this is why the law from 2011 has been called an anti-union law. Regarding the possible issues in the collective bargaining, when it comes to minimum wage, we have to emphasize that this is completely not relevant when it comes to public sector, because in the public sector, it is not allowed to negotiate the wage. The wage is provided through a piece of legislation, through a normative act. So the parties are, of course, not allowed to negotiate in pay use, in detrimental of the workers, but not even to provide a higher level of wages, because there is an envelope, a budgetary envelope for the company, for the public institution. In private sector, well, there can be some provisions related to a higher level of minimum wage than it is in legislation. During the COVID crisis, there are things that had to be said here that I think not only in Romania, but in all the countries, like what happens to collective bargaining during COVID crisis is somehow an example or a way of seeing very clear how is collective bargaining doing, generally speaking, in that country. And indeed, in Romania, it stopped completely. All the collective agreements were prolonged during the state of alert, which ended at 8th of March. So we still have 3 months from this moment for collective agreements to be in force until we will be able to negotiate others. There are a lot of things to be said here, but I will go a little bit further, talking about telework, which creates a lot of consequences, not only when it comes to actually negotiation between the parties, but to the willingness of the parties to negotiate, because it's a little bit more than just what the legislation says in this. We have a problem with the very idea of solidarity, and telework and working by yourself, not with your colleagues, not shoulder by shoulder with your colleagues in a proximity which creates all the roots for the future union organization, it could create a lot of consequences. Over-legalization may have also some consequences when it comes to collective bargaining, because the more legislation you have, the more detail you have provisions in legislation regulating the position of the parties, the less room there is for collective bargaining. And there is a certain expectation from the workers to be governed and protected by legislation and not by collective agreements, which is quite an important element. And of course, trade unions themselves could be blamed for what happens today. So what I said, there are some consequences of digitalization, even not only in Romania, but in the entire region, related to this position of isolation of worker from his colleagues, and this turning of labor law as a branch of law through individualization, as opposed to collectivity and collective labor law. It's like Netflix replacing cinemas. we are supposed to work by ourselves as a lone wolf instead of organizing in solidarity. Well, finally, a few words about what happens next after such a collective bargaining, supposing that a collective bargaining even begin. There are two possibilities: happy end, which is conclusion of collective agreement. Once we conclude a collective agreement, of course, from that moment, no strike is allowed anymore. Or the parties disagree, and then we may have a collective dispute which could be solved under Romanian legislation, either by conciliation or mediation or arbitration. We have them all, but we don't really use them. Conciliation is obligatory in the sense that without conciliation, you cannot go further with your collective dispute, and you can clearly go to strike. A strike would be illegal without conciliation. Conciliation is this attempt to solve the dispute in front of a representative of the Ministry of Labor, who is not a professional, is just a civil servant. He came and tried to do his best to solve the dispute. So this is conciliation. In most of the cases, parties go to conciliation because otherwise the collective dispute would immediately stop. Mediation could have been more useful, but is never used, almost never used, because mediation is in front of a professional, of someone who knows what he's doing. But because it's not obligatory, because it's facultative, parties don't normally go to mediation, nor they do go to arbitration, which is almost never found into Romanian practice, but it is in law, in legislation, so it is theoretical possible. And finally, from conciliation, we can have, of course, an agreement or not, and in case of no agreement, we can go to strike. So what I wanted to say is that we do have in Romania the same challenges as in other countries, starting with globalization and digitalization, a competitive relation between workers, which again has something to do with lack of solidarity, certain pressure from consumers, new type of management methods directed towards autonomy, again with consequences upon solidarity, some problems with trade unions, which are shared with the trade unions from other countries in the region, as I notice, significant image deficit of trade union. All of them matters, but again, we also have one more problem, which is the law on social dialogue. Despite all the attempts of trade unions to change this piece of legislation, it is still in force and still produces these unfortunate effects, leading to contraction and even collapse of collective bargaining to disturbing levels. Thank you.
Perhaps, yeah. Thank you very much. It was clear, and you have right to what's that? Okay, you have right to emphasize the individualization of the work of the company that leads to a lack of collective agreement. And also you are right to underline the notion of representativeness, how could affect the collective bargaining. So we have seen here in Romania that the way of constructing this notion may lead to a very negative effect. Thank you very much. So the floor is to you to have some questions. Ivana.
Thank you. All three presentations were very informative, and I would like to thank to all of them. But the last one was so. The results are very disturbing, namely the conclusion. So it seems to me that it's almost abolished the right to associate in trade unions. What was the reaction of trade unions? Did they approach to ILO monitoring bodies, because it's the core standard, right, to associate? So could you explain this?
Yes, there were already decisions and recommendations from the Committee of Union Freedom in this respect related to, and also the Economic Social Charter has been not observed by this idea of having 15 members from the same unit in order to organize a trade union. So yes, there were some reactions from international organizations, and trade unions are doing their best, but they don't have such a high credibility into the Romanian society right now. So even though they are right in this aspect, they may not be right in others in their public statements. So they are not really efficient in trying to change things. But what we do, you can find in Romanian juridical literature. I mean, all the scholars are trying to write, so we are the ones who are really fighting for this, but not really trade unions. I mean, they do express themselves, but again, I don't know with which effect, not so far.
Θα μιλήσω στα ελληνικά για να είμαι λίγο προσεκτική. Πρώτον, είμαι πολύ ευχαριστημένη που είχα αυτή την ευκαιρία να ακούσω όλα αυτά τα στοιχεία των γειτονικών μας χωρών και να προσπαθήσω να τα δω με μια ενιαία οπτική. Βλέπω λοιπόν ότι τι είναι τα 30 χρόνια του ΟΜΕΔ, είναι και τα 30 χρόνια μετάβασης για τις χώρες που άλλαξαν τα σοσιαλιστικά καθεστώτα, από από την κρατική οικονομία στην ελεύθερη ιδιωτική οικονομία. Και βλέπω ότι τα συστήματα τα οποία προέκυψαν αυτά τα 30 χρόνια έχουν εντυπωσιακά κοινά χαρακτηριστικά. Έχουμε χώρες που η καθεμία θεσμοθετεί μόνη της, αλλά οι θεσμοί που διαμορφώνονται, ακούω στο βαθμό που σήμερα τα άκουσα και δεν τα έχω μελετήσει σε βάθος όσο πρόλαβα να κατανοήσω, έχουν εντυπωσιακά κοινά χαρακτηριστικά. Δεν ξέρω αν το νιώθετε κι εσείς που ήρθατε και μας εκθέσατε έτσι πλούσια όλα τα στοιχεία του εθνικού συστήματος. Από αυτά τα χαρακτηριστικά υποθέτω ότι αν τα μελετήσει κανείς ανά χώρα, είχαμε την εντυπωσιακή τώρα παρουσίαση του συστήματος Ρουμανίας, θα δει τα στοιχεία τα δυνατά και τα αδύνατα και ίσως αυτό οδηγήσει σε συμπεράσματα για επιμέρους εξέλιξη των επιμέρους θεσμών, τα οποία δεν μπορώ φυσικά να κάνω τώρα. Αλλά το ότι καταλήγουμε γρήγορα σε όμοια συστήματα νομίζω ότι εμένα μου προξενεί μία εντύπωση, περισσότερο αφορά ίσως τα συμπεράσματα και ήθελα αυτό να το πω. Ακούω και κοινούς άξονες, δηλαδή αυτή η εξέλιξη αντιμετωπίζει το θέμα της ενεργείας, ψάχνουμε την εργασία, όπως και στην Ελλάδα που ξεκινήσαμε από την έννοια να εξασφαλίσουμε τα βασικά στοιχεία στη διαπραγμάτευση και φτάσαμε από το 10 και μετά να είναι η έννοια μας κυρίως να υπάρχει εργασία, το άκουσα σε πολλές χώρες να εξελίσσεται έτσι. Άκουσα στη Ρουμανία μετά το 10 να έχετε νέους θεσμούς και στην Ελλάδα μετά το 10 είχαμε νέους θεσμούς. Ακούω λοιπόν κοινά στοιχεία που χωρίς να είμαι σε θέση τώρα να τα επεξεργαστώ, μου δημιουργεί τη διάθεση να συμμεριστώ αυτή τη σκέψη μαζί σας, μήπως στη συνέχεια της συζήτησης, συμπεράσματα ή αύριο μας είναι χρήσιμη η σκέψη αυτή. Είδα, όσο κοινά στοιχεία, είδα τον ιδιαίτερο συνδικαλισμό ή την ιδιαίτερη δραστηριότητα στο δημόσιο τομέα. Στην Ελλάδα το έχουμε γνωρίσει αυτό. Ελλάδα, ίσως Κύπρο και Τουρκία, είμαστε σε διαφορετική εξέλιξη από τις χώρες που βγήκαν από το σοσιαλιστικό καθεστώς. Σε όλες τις χώρες βλέπω ότι μειώνονται ή δεν υπάρχουν στοιχεία υποχρεωτικότητας. Σε κάποιες χώρες άκουσα να μην υπάρχουν, σε εμάς εξελίχθηκαν και μειώθηκαν. Και ήθελα αυτή τη σκέψη να μοιραστώ μαζί σας, μήπως βοηθηθούμε στην κατανόηση πραγμάτων που συμβαίνουν σε εμάς. Πάντως, συνάντηση χωρών Βαλκανίων και Νοτιοανατολικής Ευρώπης επιστημονική είναι η ελπίδα της καλής συνεργασίας και ελπίζω να έχω την τύχη να ξανασυμμετάσχω σε τέτοιες συζητήσεις. Ευχαριστώ.
Ευχαριστούμε, Ελένη. Δύο ερωτήσεις. Ο κύριος Τριμικλινιώτης, ο Νίκος και μετά η Μαρία Λότσικα. Νίκο.
This was a very interesting panel, but I think it extends from the previous discussion. Certain things that I see that developing as common elements in the development in terms of the challenges of the reduction in unionization, reduction in organized types of work. So there is a convergence there, which is very interesting to think about. And I'm wondering, however, if there are any other convergence that derive from the Europeanization processes that underlie even countries which are not members of the EU. They are connected and they are kind of in a parallel, going in a parallel direction in what is going on. So I'm wondering if you can see certain elements that derive from that. That's the first issue. The second issue relates to what do you think, and I think this is something that I'm thinking about and that many of us here are thinking about, what do you think about what would be the legacy of the pandemic crisis, the way that it was regulated for the post-pandemic labor regimes? Do we see certain trends developing in the transforming the ways and means of negotiating and bargaining in terms of the collective bargaining? Is it going to be a temporary kind of process, or are we seeing some longer term processes emerging? And so in terms of the post-pandemic order, we heard some of the negative elements in terms of stifling and blocking development. But do we see any potential? And here I want to sort of take up the more optimistic potential. You know, some people have spoken, okay, we had the digitalization and telework there. We had also the what somebody called some people called the Zoom revolution. You know, the kind of potential for being forced to organize as we are and discuss now without being or present here, and whether this creates the potential for thinking about types of regulations and types of organization in a very different way as a result of the new realities of the digitalities we're experiencing now, because they are creating realities. So in terms of that, that's, you know, and then I think the other common challenges that we have that remain relate to the trends that seem to have been accelerated or accentuated as a result of the pandemic, but were there beforehand. Things like, you know, platform work and telework, and the need to regulate them and to think about how we would be organizing them and whether we can see the Europeanization processes as being a common base for developing common ways of regulating such aspects. So I'm just thinking aloud whether we should be thinking of a new collective bargaining process that takes into account these major transformations that we're living in this interesting but very challenging times. Thank you.
Thank you very much for your presentations. And despite your very, very gloomy presentation on Romania, I would like you to comment and give us an idea on why it happened in 2010, what has happened. Because at this time, there is a very strong element of the law intervening in the legal system of collective bargaining and trade union structures that gives this result, which is very, very, very dark and very, very unpromising for any progress. However, we all know that since the beginning of the last century, over the last 20 years, there was a strong discussion about the decentralization of collective bargaining. And I wonder if this notion that has been so much developed through the OECD and so deeply discussed was the impetus for your developments in Romania. On the other hand, I see, and we have experienced that in Greece also, a strong competition between trade unions as structures and employees' representatives inside the unions. And as our president has already said, Professor Papadimitriou, in Greece, the representatives of the workers on the industry level somehow do not exist, and their place is taken by the trade unions whenever and how they behave and they act in the industries. Was this difference between trade unions and workers' representation having a share in the developments you had in Romania? And also, what is the response of the employers' organizations in this atmosphere of no collective bargaining? That means no boundaries and no regulations. Thank you.
Which one you can reply? Start from Kubra. You want to say anything to reply?
I'm sorry, there's a lot of echo. Can you hear me now? I hope yes. It's okay. Okay, that's great. Thank you very much. What I would like to say that I totally agree with, I think it was Nikos, what he told me. I believe it's very important to know the different legal models and what are the consequences and experience of the other countries. When we start, you pointed out that we have a conflict-based cultures in Balkanian countries. So it's not always easy for us to find a concession in the bargaining table. At least that's Turkish experience. And I found it's quite important to learn and to see what's going on in the neighboring country and sharing experiences. And the Europe, even though Turkey is not a member country, and European regulations constitute a kind of base for those who are looking for a solution. In terms of we have, at the beginning of 2000, Turkey was much more ambitious in making its legislation in harmony with EU regulations. So we have a lot of new rules coming from Europe, workers' representatives, the idea of social dialogue, participation of employees, these are all important institutions which are inserted into the legal system. Not as developed as we wish, but at least we have some base structures. And also with regard to the platform economies, I totally agree that there are a lot of young academics working on the issue, working on the EU rules and looking what are the best solutions, and then it becomes a source of inspiration for the future. So that's how I see it. I can see that industrial relations is a kind of more problematic area because it's not only law, there's a lot of sociological base to regulate these relationships. But at the end of the day, we can see the possible good ideas. We can learn good ideas from each other. Thank you.
Thank you, Kubra. Thank you very much. I think I thought there's no, but if you want to say something. Yeah.
Okay, so thank you very much, Nikos, particularly for bringing this issue of thinking about the, so to say, Europeanization in terms of collective bargaining, industrial relations system. The perception, at least in North Macedonia as a candidate country, that the national, so to say, narrative goes from times when we were obsessed by copy-pasting, in a way, these European Union directives, not in order to improve the labor legislation, but in order to, prepare the homework for the Brussels progress reports. So this is one issue. The other issue is to find the real substance underlying those directives, and one of the things is the uniformity. Although collective labor law is not protected by the social acquis, not in the sense of individual labor law, but anyway, there are things that can be improved in that particular regard. So speaking about, again, about the legacy that the pandemic left, my impression, observing how trade unions and employers associations interacted in these 2 or 3 years already, is that they started these negotiations, but without the government to interfere, without this tripartite dialogue to be ongoing, directly, one-on-one, they cannot settle the things. They had this hot potato to regulate. I even advised them taking into consideration, for instance, the European Framework Agreement on telework, because trade union officials and their staff were also teleworking during the pandemics, and they sat on the table but didn't, agree to regulate telework through collective agreements. Yes, although, as I said, there was a lack of collective bargaining in this process, the thing that was good in a way was that in the Economic and Social Council, we witnessed a progress. So the sides sat at the table, they regulated jointly, for instance, issues such as subsidies for affected employers, subsidies for, again, some allowances for, so to say, for precarious groups in the society, and so on and so forth. This is a progress that I saw. Thank you.
Luca, many questions for you.
I wanted to start by saying that employers are not in a landscape without limits, because there are limits imposed by legislation. We do have legislation, even a very detailed one. And as I said, over-legalization is even a problem for collective bargaining, because there is not so much room in order to negotiate. Regarding of what happened in that particular year in 2010, this is somehow linked to another question. It was a lobby made by a committee which is called Foreign Investors Committee, which are not only European, but most of them are from United States. So I wouldn't blame European for this so much. And they are not an employers organization. actually. It's just a committee, and they made an important lobby in that moment, succeeding to impose this piece of legislation. Regarding the question related to COVID crisis and which is the legacy of this crisis, well, from a juridical point of view, if we look to the legislation adopted during this crisis, it is not really labor law legislation. It is protection, assistance, social protection, things that regulate temporarily financial situation of some of the workers. But it could be a legacy, perhaps from a psychological point of view, related to the way the workers, I don't know, faced the same problem together, perhaps, I don't know. And regarding the decentralization of the collective bargaining, there is something I wanted to mention, that there is even another consequence of decentralization, is that lowering the center of gravity from the higher level to the level of a company has made the work of trade union federations and confederations less important than it used to be. And then there is a vicious circle, in the sense that they are not so important, so their work becomes not so efficient. So decentralization can create some effects in the organization of trade unions, even at the national level, in federations and confederations. This is what I writing down. I don't know if I missed anything.
Okay.
Thank you.
Thank you very much. And now the last parts, the conclusions. Κύριος Κουκιάδης έκανε τη δύσκολη δουλειά. Τον ευχαριστώ πολύ για αυτό. Σημείω όλη την ώρα, αλλά νομίζω ότι είναι ο ικανότερος για να εκπληρώσει αυτό το έργο. And now Mr. Kukiadis is going to make the conclusions. One of the worst words and more tiring words. Professor Kukiadis. No, I think Kalista.
Καταρχήν, να πω τον φίλο μου Παπαδημητρίου, δεν φίδεται κολακευτικών λόγων και του λέω, λες πολλά και θα τα εκμεταλλεύουμε μετά, όπως τα λέτε. Να ευχαριστήσω βέβαια τον ΟΜΕΔ για την πρόσκληση και για τον ρόλο που μου αναθέτει από τα συμπεράσματα και βέβαια να τον συγχαρώ γιατί αυτό το σεμινάριο, συνέδριο, έχει βάθος. Είχαμε κάνει μια φορά στο παρελθόν, είδε και τώρα, ελπίζω να συνεχιστεί, διότι αυτή η αλληλοσυμπλήρωση θα βοηθήσει και τα συνδικάτα και τις κυβερνήσεις να βρουν καλύτερες λύσεις στον χώρο της Νοτιοανατολικής Ευρώπης που δεν ταυτίζεται με τα προβλήματα της Κεντρικής Ευρώπης. Παρόλο ότι δεν νομίζω μπορεί να γίνει πλήρη αποστασιοποίηση. Δηλαδή η επιρροή της Κεντρικής Ευρώπης υπάρχει παντού και σε αυτά τα συστήματα. Θα μου επιτρέψετε πρωτού περάσω στα συμπεράσματα να πω κάτι το οποίο δεν έχει σχέση με το συνέδριο. Αυτό το συνέδριο γίνεται σε αυτό το ίδρυμα του Τελλόγλειο, το οποίο έχει μια ιστορία 50 ετών, είναι ένα ίδρυμα κληροδότημα από ιδιώτη, ο οποίος χάρισε και τη συλλογή του στο Τελόγλειο. Είχατε τύχει να είμαι στο Συμβούλιο από την αρχή, όταν χτιζόταν, το οποίο έζησα τις περιπέτειες, γι' αυτό το λέω κυρίως, τις οποίες γνωρίζει κάθε πολιτιστικός φορέας ό,τι θέλει να αναπτυχθεί. Δηλαδή, ό,τι έζησε το Μουσείο Ακροπόλεως σε μεγάλη έκταση, το ζήσαμε εμείς. Δηλαδή, για να φτάσουμε να το χτίσουμε, είχαμε 7 χρόνια δικαστικούς αγώνες από γείτονες, οι οποίοι φοβούνταν ότι θα χαλάσει το περιβάλλον. Έχει σημασία αυτό για την ελληνική νοοτροπία. Λοιπόν, τώρα έχει εκθέσεις μόνιμη του Τελλογλείου, περιοδικές και μάλιστα και διεθνείς. Έχει φέρει εκθέσεις με το Μουσείο Ισπανίας και Γαλλίας. Είναι, νομίζω, ένα πολύ καλό, θα έλεγα, συμπλήρωμα του Πανεπιστημίου Θεσσαλονίκης. Τώρα, όσον αφορά τα συμπεράσματα, βέβαια τα συμπεράσματα τα περισσότερα τα είπατε. Ένας από εδώ, λίγο από εκεί, ελέγχθησαν πάρα πολλά. Και δεν ξέρω τι μπορώ να πω. Έχω τη γνώμη όμως ότι πιο σωστό να ακολουθήσω. Συγγνώμη, ήθελα πρωτού αρχίσω τα συμπεράσματα, επειδή νομίζω έφυγε η Βουλγαρία. Εντάξει, τα αφήνω. Λοιπόν, περνάμε τώρα εδώ. Θα ακολουθήσω την εξής μέθοδο. Ήθελα να σας ευχαριστήσω που θυμηθήκατε τα παλιά χρόνια, πριν από 30-40 χρόνια, το Πανεπιστήμιο Θεσσαλονίκης έκανε ανταλλαγές με το Πανεπιστήμιο της Σόφιας, πηγαίναν φοιτητές, καμιά 30 εκεί, ερχόταν εδώ πέρα και έτσι πριν από την κατάρρευση του υπαρκτού του σουρεαλισμού είχαμε αναπτύξει πάρα πολύ καλές σχέσεις. Ευχαριστώ πάρα πολύ, να είστε καλά. Λοιπόν, όσο αφορά τη μέθοδο, θα πω μερικά πράγματα. Μια περιοριολόγηση σε αυτά που λέχθησαν, διότι είναι αδύνατον να λεχθούν πάρα πολλά. Θα ξεκινήσω από τη Σερβία. Και αυτό που θα πω για τη Σερβία ισχύει και για τις άλλες χώρες. Η μετάβαση από τη διφθενόμενη οικονομία στην ελεύθερη οικονομία, όπως αντιλαμβάνεστε, είχε πολλά προβλήματα και ήταν δύσκολη η προσαρμογή. Άρα λοιπόν οι περισσότερες από αυτές τις χώρες έχουν ξεχωριστά προβλήματα που δεν τα έχει η Ελλάδα, διαφορετικά έχει η Τουρκία, άλλο έχει η Κύπρος. Πάντως αυτό πρέπει να το λάβουμε υπόψη, κάνουν προσπάθειες. Φαίνεται όμως, αυτό μου κάνει εντύπωση, ότι εξακολουθεί να παίζει μεγάλο ρόλο αυτό που λένε δημόσιο, σε σχέση με το ιδιωτικό. Στις περισσότερες χώρες ακούσαμε ότι οι συλλογικές διαπραγματεύσεις στον δημόσιο τομέα είναι πιο ισχυρές, πιο αποτελεσματικές από ό,τι στο ιδιωτικό. Αυτό είναι εντυπωσιακό και θέλει μια εξήγηση. Βέβαια, όταν λέμε δημόσιο τομέα, εννοούμε όχι το δημόσιο εν τη ενιαία, και είναι ξεχωριστό, εννοούμε εταιρείες που ελέγχονται από το δημόσιο. Δεν είναι για να μην παρεξηγούμε, γιατί το δημόσιο με τη στιγμή έννοια είναι τελείως διαφορετικό και έχει τελείως διαφορετικούς κανόνες. Στην Ελλάδα, βέβαια, μετά την αναγνώριση του δικαιώματος συλλογικής διαπραγμάτευσης, μπορούμε να πούμε ότι γίνεται μια εξομοίωση με το ειδικό τομέα, αλλά πρέπει να σας πω ότι αυτή η συλλογική διαπραγμάτευση στο δημόσιο με τη στιγμή έννοια ποτέ δεν πραγματοποιήθηκε. Και αυτό είναι σημαντικό. Λοιπόν, είχαμε πρώτα αυτό. Δεύτερον, κατάδυση είναι η αδυναμία διαπραγμάτευσης. Αυτό είναι βασικό στοιχείο, διότι όλο το σύστημα των συλλογικών διαπραγματεύσεων προϋποθέτει πρώτα να δημιουργήσουμε την ικανότητα διαπραγμάτευση, τη βούληση διαπραγμάτευση, το περιβάλλον για διαπραγμάτευση. Λοιπόν, αυτά τα στοιχεία από ό,τι κατάλαβα δεν υπάρχουν στη Σερβία και δεν υπάρχουν και στις άλλες χώρες και αυτό είναι μεγάλο μειονέκτημα. Στη Σερβία μου εντυπωσίασε ότι αναγνωρίζεται μεσολάβηση την προληπτική μεσολάβηση. Κάτι το οποίο εδώ δεν ισχύει έτσι προληπτική μεσολάβηση. Είναι μια ιδιαιτερότητα και έχει σημασία διότι προφανώς αυτό συνδέεται και με περιορισμό του δικαιώματος απεργίας. Είναι λίγο, θα έλεγα, με αυτή την έννοια, λίγο ύποπτη αυτή η ρύθμιση. Αυτό θα ανακατήσουμε. Η Κύπρος είναι ξεχωριστό θέμα. Δεν είναι Βαλκάνια. Δεν είναι υπηρετικό δίκαιο. Είναι άκρος κανονικό δίκαιο. Άρα δεν μπορούμε να κάνουμε σύγκριση με τις άλλες χώρες. Έχει μια ιδιαιτερότητα, πάντως είναι εντυπωσιακό, τουλάχιστον αυτό κατάλαβα εγώ, ότι έχει ενισχυμένο, και ας με διαψεύσει ο συνάδελφος, τον τριμήνη διάλογο. Είναι σημαντικό αυτό, που στη δική μας χώρα, αλλά και σε πολλές άλλες χώρες, είναι υποβαθμισμένος. Ο τριμήνης διάλογος, ο κεντρικός, είναι διάλογος των γενικών επιλογών, των κεντρικών επιλογών. Και με αυτή την έννοια είναι πάρα πολύ χρήσιμος να περάσει τις παραδόσεις και των άλλων χωρών. Επίσης, κράτησα ότι η προσφυγή σε τρίτους, μεσολάβηση ζητησία, μάλλον είναι περιθωριακή, τουλάχιστον υπάρχει μια προσφυγή στη μεσολάβηση, αλλά τελείως περιθωριακή. Άρα το κεντρικό σύστημα στηρίζεται στην αμοιβαία συνεννόηση. Έχω δίκιο. Δεν με κάνω και κανένα λάθος και παραπλανήσω. Λοιπόν, αυτό είναι βασικό. Και είναι και ένα, θα έλεγα, και ένα σημείο που θα πρέπει να κρατήσουμε υπόψη εμείς και οι άλλες βαλκανικές χώρες για την προόδο και τον εξυγχρονισμό των συλλογικών διαπραγματεύσεων. Είναι αυτό το στοιχείο που λείπει. Είτε έτσι είτε αλλιώς, και εκεί υπάρχουν διαφωνίες, συγκρούσεις, τα βρίσκουν. Αυτό είναι βασικό για να περπατήσει όλο το σύστημα συλλογικών διαπραγματεύσεων και να αποφύγουμε αυτές τις απαγορεύσεις και τους περιορισμούς που είδα στις διάφορες χώρες που τίθενται, που είναι νομίζω τελείως άχρηστες. Όσον αφορά τώρα την Βουλγαρία, και εδώ όπως στις άλλες χώρες είναι σαφές η μείωση των συνδικαστικών οργανώσεων, η μείωση των μελών της αντιπροσωπευτικότητας και κατά τρίτο λόγο αυτόν και η μείωση της δυνατότητας επιρροής των συνδικαστικών οργανώσεων. Η αντιπροσωπευτικότητα δεν είναι μόνο θέμα μελών αριθμού, είναι και δυνατότητα επιρροής. Αυτό είναι ένα καινούριο στοιχείο που ισχύει και για την κεντρική Ευρώπη και απασχολεί πάρα πολύ όλους πώς θα επανακτήσουν τη δυνατότητα επιρροής. Θα επανέλθω σε αυτό το θέμα. Επίσης, η Βουλγαρία μας έδειξε ότι το περιεχόμενο των συλλογικών συμβάσεων δεν είναι μόνο τα εργασιακά, είναι και θέματα ασφαλιστικά. Αλλά και εκεί είδα ότι ο δεύτερος τομέας περιεχομένου έχει μικρό περιθώριο. Και σε Ελλάδα προβλέπονται τα ασφαλιστικά πριν τα συνταξιοδοτικά και εδώ δεν έχουμε νομίζω μεγάλη εφαρμογή αυτού του θεσμού. Νομίζω ότι ο κ. Παπαδημητρίου το είπε, η ανάπτυξη των επαγγελματικών συστημάτων δίνει λαβή για τη διεύρυνση αυτού του τομέα της συλλογικής διαπραγμάτευσης. Νομίζω εκεί είναι ο προσανατολισμός, δηλαδή η πρόβλεψη, η ρύθμιση επαγγελματικών συστημάτων ασφάλισης. Και εδώ πάλι επανέρχεται η διαφορά ιδιωτικού και δημόσιου τομέα. Τώρα, δεν είναι ένα θέμα που ισχύει και για τις άλλες χώρες, αλλά που δεν έγινε πλήρως κατανοητό. Στην Βουλγαρία, από ό,τι κατάλαβα, οι επιχειρησιακές συλλογικές συμβάσεις ισχύουν και είναι σε κάποια είδος, θα έλεγα, πρόοδου. Αν το πιες αυτό, γιατί ήταν και μετάφραση που το λέω αυτό, διότι αυτό είναι ένα άλλο θέμα που θα το πω στα τελικά συμπεράσματα. Αυτή η τάση σήμερα για αποκεντρωμένο συλλογικό σύστημα διαπραγμάτευσης. Υπάρχει λοιπόν λίγος πολύ και σε άλλες χώρες, το είδα και στην Βουλγαρία. Εκείνο που είναι ενδιαφέρον και για τον ΟΜΕΔ είναι ότι τελικά και στην Βουλγαρία αλλά και σε άλλες χώρες η υποχρεωτική διαιτησία με την έννοια της μονομερούς προσφυγής δεν πρέπει να αποτελούσε αντικείμενο μείζωνος ενδιαφέροντος όπως στην Ελλάδα. Όπως στην Ελλάδα. Το λέω για τις άλλες χώρες. Και γιατί στην Ελλάδα? Γιατί πρέπει να το κατανοήσω. Όταν έγινε ο νόμος, είχα την τύχη να είμαι ο πρόεδρος της Επιτροπής το 1987. Όλοι και εργαζόμενοι και εργοδότες ήταν αντίον της υποχρεωτικής διαιτησίας. Ήταν το μεγάλο σλόγγαν. Κάτω η υποχρεωτική διαιτησία. Η σκέψη που επικράτησε και πέρασε είναι ότι ωραία, όχι υποχρεωτική διαιτησία. Τι κάνουμε, αυτή ήταν η αρχική σκέψη, τι κάνουμε με τις μικρές οργανώσεις που δεν έχουν ικανότητα να συνάψουν συλλογική σύμβαση. Πώς θα πετύχουμε να πάρουν ένα μισθό, μια αύξηση 1-2% ένα επίδομα? Η εναλλακτική λύση ήταν το κράτος. Οι εργοδότες δεν θέλαν μείζωνο κρατική παρέμβαση. Και έτσι συμφώνησαν και οι εργοδότες και οι εργαζόμενοι να περάσει το σύστημα της μονομερούς συνδιαιτησίας, ώστε όμως ως έσχατο μέσο έχει σημασία. Και έτσι λειτουργήσε στην αρχή και είχαμε μεγάλο περιορισμό των διαιτητικών αποφάσεων, Στη συνέχεια όμως στην πράξη έγινε διαστρέβλωση και άρχισαν να προσφεύγουν και μεγάλες οργανώσεις και τελικά ήρθαν η εποχή και του μνημονίου που την κατάργησε, επανήλθε, προσφύγασε στα δικαστήρια και τελικά με τελική απόφαση του Συμβουλίου Επικρατείας έγινε δεκτή η συνταγματικότητα της μονομερούς προσφυγής και επανήλθαμε. Αλλά προσέξτε, το σύστημα λέει σε περίπτωση αποτυχία των διαπραγματεύσεων διαδιαιτησίας. Πολύ ωραία. Δεν λέει πουθενά όμως τι συνιστά αποτυχία διαπραγματεύσεων. Και έτσι λοιπόν ήρθε ο τελευταίος νόμος και άρχισε έβαλε μια σειρά από υποθέσεις που ουσιαστικά το να πάει καλά στη διαιτησία είναι πρόβλημα. Θέλει τόσες ιδεολογίες, τόσες ιδεολογίες όχι μόνο από τους προσφεύγοντες και από την απόφαση, που υπάρχει μεγάλος κίνδυνος να βγαίνουν άκυρες αυτές γιατί θα υπάρχει προσφυγή στα δικαστήρια. Όταν μιλάει για ένα μέσο, μιλάει με την προϋπόθεση να εξαντληθεί η συνδικαλιστική δράση. Με προϋπόθεση το δημόσιο συμφέρον να μην αντίκειται. Με την προϋπόθεση στις επιχειρήσεις να υπάρχει αναγκαιότητα. Προϋποθέσεις που επαναλαμβάνουν δεν θα συγκεντρωθούν. Άρα ουσιαστικά καταλήγουμε σήμερα σε ένα σύστημα περιορισμένης εφαρμογής. Το είπε ο πρόεδρος. Νομίζω 3-4 συμβάσεις γίνονται το χρόνο, κάποτε γινόταν 40-50. Βλέπετε λοιπόν πώς μεταξελίσσεται ένας θεσμός από διάφορες συγκυρίες. Αυτό νομίζω είναι ιδιαίτερο ενδιαφέρον. Στο Μαυροβούνιο μένουμε την εντύπωση, το τονίζω αυτό γιατί ότι αναγνωρίστηκε η Εθνική Γενική Συλλογική Σύμβαση. Είναι εδώ εκπρόσωπο του Μαυροβουνίου. Έχω δίκιο. Λοιπόν, αυτός είναι ένας θεσμός χρήσιμος. Και σε αυτό το σημείο η Ελλάδα πρωτοτυπεί. Στις περισσότερες χώρες δεν υπάρχει Εθνική Γενική Συλλογική Σύμβαση. Είναι πολύτιμος θεσμός, διότι απεδείχθη σε όλη την ιστορία με την Εθνική Γενική Συλλογική Σύμβαση δημιουργείται ένας πιλότος που θα πάνε επιμέρους διαπραγματεύσεις. Όλες οι άλλες κρατικές επιχειρησιακές, λίγος πολύ στα βασικά θέματα ακολουθούν την Εθνική Γενική. Και επιπλέον δίνει τη δυνατότητα να εξασφαλίσουμε αυτό που λέμε το γενικό κατώτατο μισθό σε όλους τους Έλληνες, είτε είναι συνδικαλισμένοι είτε όχι. Η ρύθμιση η νεότερη που προβλέπει το νομοθετικό καθορισμένο γενικό κατώτατο μισθό αλλιώνει λίγο το πρόβλημα, αλλά αυτό δεν θα ασχοληθούμε σήμερα γιατί δεν αφορά το παρόν. Πάντως η Εθνική Γενική Συλλογική ως θεσμός θεωρώ ότι είναι κεκτημένο πολύτιμο για την Ελλάδα. Το έχει ακόμα νομίζω το Βέλγιο, δεν θυμάμαι καλά. Οι περισσότερες χώρες δεν το έχουν. Και είναι λάθος, αποδεικνύεται σε πολλές φορές χρήσιμο. Ακόμα και για την επέκταση ή εφαρμογή ενσωμάτωσης μιας οδηγίας. Είναι χρήσιμος σήμερα. Και αυτό πρέπει να το κρατήσουμε. Ένα θέμα το οποίο ισχύει και για τις άλλες χώρες, αλλά το είδα τελευταίως, με ιδιαίτερη έμφαση, Κροατία, Ρουμανία κλπ. Είναι το περίφημο θέμα της αντιπροσωπευτικότητας. Απασχολεί όλες τις νομοθεσίες. Αλλά όταν λέμε αντιπροσωπευτικότητα, δεν νομίζουμε το ίδιο πράγμα. Ούτε όσο αφορά τα κριτήρια αντιπροσωπευτικότητας, ούτε όσο αφορά το ρόλο της αντιπροσωπευτικότητας. Τα κριτήρια, όπως είδατε, ποικίλουν από χώρα σε χώρα και μερικές φορές είναι τόσο αυστηρά που ουσιαστικά εκμηδενίζει την ελευθερία συνδικαλιστικής δράσης. Αυτό καθίζεται. Δεν ισχύει στην Ελλάδα και στην Ελλάδα αντιπροσωπευτικότητα. Η αντιπροσωπευτικότητα λαμβάνεται υπόψη άλλοτε για να μπορούν να συνάψουν συλλογική σύμβαση, άλλοτε για το πόσα μέλη μετέχουν, άλλοτε για τις, όπως στην Ελλάδα, που είναι για την επέκταση γενικής συλλογικής σύμβασης. Έχει διάφορους ρόλους. Είναι ένα θέμα λοιπόν που πρέπει να συζητηθεί σε βάθος ποιος ο ρόλος της αντιπροσωπευτικότητας, χωρίς να φύγεται ο πυρήνας συνδικαλιστικής ελευθερίας. Όταν η αντιπροσωπευτικότητα, που ισχύει και στην Ευρώπη, λαμβάνοντας κριτήριο για να υπάρχει μία, θα έλεγα, μαζική ανταπόκριση, να μην αφορά 2 ή 5 εργαζόμενους, αφορά ένα αριθμό εργαζόμενων. Για τη συλλογική σύμβαση είναι νόμος. Δεν μπορεί να είναι νόμος για 5 άτομα, πρέπει να υπάρχει λοιπόν μια μαζικότητα. Εκεί λοιπόν πρέπει να υπάρχει συγκερασμός πώς θα εφαρμοστεί η αντιπροσωπευτικότητα για να εκπληρεί το ρόλο της συλλογικής σύμβασης, που πρέπει να έχει ένα διευρυμένο πεδίο, από τις περιπτώσεις που είδα στις διάφορες χώρες, όπου η αντιπροσωπευτικότητα ουσιαστικά είναι και μέσω καταστρατήγησης των δικαστικών ελευθεριών. Αυτός είναι ο κίνδυνος και νομίζω πρέπει να το προσέξουμε. Επίσης, και στην Κροατία είδα ότι η μεσολάβηση μου έκανε εντύπωση. Είναι μέσο και μάλιστα κρατάει και πολλές μέρες, είδα, αν κατάλαβα καλά, αποκλεισμού της απεργίας. Αυτό είναι επικίνδυνο. Διότι αν θέλουμε τους θεσμούς παρέμβασης τρίτων, μεσολάβησης διαιτησίας να τους διασώσουμε, πρέπει να τους αποξενώσουμε, να τους απομακρύνουμε από τα θέματα απεργίας. Διότι τότε υπάρχει πλήρη δυσπιστία για την αποστολή των θεσμών αυτών. Είναι ένα κρίσιμο θέμα. Στην Ελλάδα το είχαμε λύσει και θα έλεγα ήταν και το κόκκινο πανί των συνδικάτων. Από τη στιγμή που δέχτηκαν την ήπια μορφή διαιτησίας, είπαν σε κάθε περίπτωση όχι αποκλεισμό της απεργίας. Και νομίζω σε αυτό το σημείο είχαν δίκιο και το δέχτηκαν και οι εργοδότες. Το ίδιο ισχύει και για την Βόρεια Μακεδονία, που επίσης με πάρα πολύ λεπτομέρεια αναφέρθηκε στο θέμα αντιπροσωπευτικότητας. Ένα θέμα που επίσης διατρέχει τις διάφορες νομοθεσίες είναι το περίφημο θέμα της ευνοϊκότητας, η οποία μέχρι τη δεκαετία, ας το πούμε, πριν από την παγκοσμιοποίηση, εν πάση περιπτώσει δεν μου πάρω ορόσημο, ήταν ένα, θα έλεγα, βασικό και εκτιμένο δικαίωμα των εργαζομένων. Αυτή η ευνοϊκότητα, λοιπόν, άρχισε να υπόκειται σε ρογμές διαφόρου τύπου, θα πω μερικά πάνω στο τέλος, με αποτέλεσμα να είναι μέσω, θα έλεγα, αποδυνάμωσης των συλλογικών διαπραγματεύσεων σε κατώτερο επίπεδο και έτσι να νοθεύσει το λεγόμενο πολυεπίπεδο σύστημα διαπραγμάτευσης. Και αυτή παίρνει άλλο τη μορφή του επιτρεπτού της ευνοϊκότητας, της δυσμενέστερης ρύθμισης σε σχέση με μια συλλογική που θα έλεγα μέχρι ένα σημείο οριακά με ορισμένους όρους δικαιολογείται, εφόσον συμφωνείτε και εφόσον πρόκειται για συνδικάτα ισχυρά, θα σας επανέλθω, και άλλο το παίρνει τη μορφή δυσμενέστερων ρυθμίσεων και απέναντι στην νομοθεσία. Αυτό είναι ακόμα χειρότερο. Διότι υποτίθεται η νομοθεσία διασφαλίζει τα αναγκαία κατώτατα όρια. Τώρα, αν η νομοθεσία, κάποιος κλάδος ή κάποιο επάγγελμα χρειάζεται μια ειδική ρύθμιση, εκεί μπορεί να κάπως να δικαιολογηθεί, αλλά θα έλεγα προτιμότερο είναι να μεριμνήσει η πολιτεία που είναι αυτή η κλάδη, παρά να τα αφήσει ελεύθερα, διότι θα αρχίσουν αμφισβητήσεις για την νομιμότητα της απόκλησης. Εν πάση περιπτώσει, είναι γεγονός ότι η δεσμενέστερη ρύθμιση ή ο μετριασμός της ευνοϊκότερης ρύθμισης έχει περάσει σε όλες τις νομοθεσίες και όχι μόνο στα Βαλκάνια. Η Τουρκία είναι λίγο ξεχωριστή περίπτωση βέβαια από τις βαλκανικές χώρες, το είπε. Εκεί είδαμε πάλι το φαινόμενο της μείωσης των συνδικάτων, της μείωσης των μελών. Μας είπε ότι το σύστημα είναι συγκεντρωτικό, με κάποια αμφιβολία βέβαια για το τι ακριβώς εννοούσε. Αλλά εκείνο που με έκανε εντύπωση, αν την κατάλαβα καλά από την μετάφραση, μίλησε ότι η ευνοϊκότητα μπορεί να ανατραπεί, δηλαδή να είναι δυνατή η δυσμενέστερη ρύθμιση με τη δημόσια αρχή. Το οποίο είναι το πιο επικίνδυνο. Διότι αν πρόκειται να έρθει η διοίκηση να καθορίζει, καταλαβαίνετε πολύ καλά ότι περιθώρια σε δικαστικές ρυθμίσεις δεν υπάρχει. Δεν είναι θέμα διοίκησης, είναι θέμα αυτονομίας, δηλαδή είναι που είναι η ρύθμιση περιοριστική. Αλλά μην την αποκλείσουμε για την αυτονομία, γιατί την βάλαμε στην κρατική διοίκηση, αυτό είναι το πιο επικίνδυνο από όλα και πρέπει να τα αποφεύγουμε. Επίσης, η μεσολάβηση προβλέπεται, πάλι όμως συνδέεται με την απεργία. Το οποίο για μένα είναι η χειρότερη λύση. Άλλο μεσολάβηση, άλλο συνδικαλιστική δράση. Εδώ έρχεται σήμερα ο νομοθέτης και είναι περίεργο, εντυπωσιακό. Για πρώτη φορά στην ιστορία την ελληνική, βλέπω τον νομοθέτη να λέει ότι για να πάτε στην διαιτησία πρέπει να εξαντλήσετε τη διαπραγμάτευση και κάθε μέσω συνδικαλιστικής δράσης. Δεν ξέρω αν το κατάλαβε ο νομοθέτης τι κάνει. Ουσιαστικά τους λέει αγωνιστείτε, απεργήστε και μετά πάτε. Αυτό δεν έχει ξαναγίνει. Αλλά πάση περιπτώσει, θα το λέω ότι στην Ελλάδα δεν μπορούσε ποτέ να υπάρξει ο θεσμός με κατάργηση του θεσμού απεργίας και αυτό πρέπει να ισχύει στις άλλες χώρες αν θέλουν να συμβαστούν ένα από τα βασικά δικαιώματα. Να μην επεκταθώ άλλο στο Μαυροβούνιο και η Ρουμανία, γιατί ουσιαστικά η Ρουμανία έβαλε πολλά θέματα για το ποσοστά αντιπροσώπευσης, για το, θα έλεγα, ιδιαίτερο θέμα που δεν το έχω ξανακούσει, ότι αν δεν υπάρχουν συνδικαλιστικές οργανώσεις μπορεί να διαπραγματεύονται οι ιδιώτες, το οποίο είναι λίγο, θα έλεγα έτσι, εξωφρενικό με την έννοια. Δηλαδή, τι θέλει να πει, ότι να υποκαταστήσουμε τις συνδικαλιστικές οργανώσεις από τα άτομα. Δεν ξέρω, δεν μπορούμε να το πιάσουμε ακριβώς, γιατί αυτά τα θέματα θέλουν και συζήτηση μεγάλη για να δούμε και τη φιλοσοφία τους πέρα από τις τυπικές ρυθμίσεις. Και τώρα έχουμε στα τελικά συμπεράσματα, θα μου επιτρέψει λίγο χρόνο, γιατί αυτά αξίζουν και περισσότερο νομίζω. Ξεκινάω από το βασικό θέμα, ότι όλα αυτά που συζητάμε σήμερα συνδέονται με τα συλλογικά δικαιώματα. Παρά τους κλειδονισμούς, παρά τις επεμβάσεις του νεοφιλελισμού, παρά τις επιδιώξεις των ευαλωτών, η Ευρώπη ανθίσατε, χοντρικά, τουλάχιστον η κεντρική Ευρώπη, δεν μιλάω για τα Βαλκάνια, στη διαφύλαξη των συλλογικών δικαιωμάτων. Και νομίζω δεν μπορεί να κάνει διαφορετικά, αν θέλει να διατηρήσει την ταυτότητά της, για τα συλλογικά δικαιώματα είναι ουσιαστικά το κορυφαίο δείγμα του δυτικού νομικού πολιτισμού. Ό,τι έχει να προσφέρει η νομική επιστήμη στον 20ο αιώνα ήταν η πλήρη θεμελίωση των συλλογικών δικαιωμάτων. Συλλογική διαπραγμάτευση, συνδικαλισμός, απεργία, συλλογικές συμβάσεις και ούτω καθεξής. Γιατί για πρώτη φορά στην ιστορία τη νομική, από τα ατομικά συμφέροντα, την ατομική σύμβαση, αναγνωρίζουμε συλλογικά συμφέροντα, συλλογική σύμβαση. Και όχι μόνο αυτό, στη συνέχεια και άλλοι φορείς, οι καταναλωτές, οι περιβαλλοντολόγοι, εκμεταλλεύουν την έννοια του συλλογικού δικαιώματος. Άρα δεν μπορεί να υπάρξει σύγχρονη κοινωνία χωρίς κάποια συλλογική ευθύνη, χωρίς κάποια συλλογική ρύθμιση. Αυτό νομίζω είναι που πρέπει να κρατήσουμε. Τώρα, από εδώ και πέρα. Από εδώ και πέρα αρχίζει το ψαλίδισμα της Μαργαρίτας. Με διάφορους τρόπους προσπαθούν να τα περιορίσουν. Έμεσα και καλυμμένους, όπως θέλετε. Αλλά δεν πρέπει η πετιότητα να στραφεί μόνο στο κράτος της εργοδότησης. Η αποδυνάμωση των συλλογικών δικαιωμάτων οφείλεται σε μεγάλο βαθμό στο ίδιο το συνδικαλιστικό κίνημα. Που σε ορισμένες περιπτώσεις είναι επέτειο, σε ορισμένες υφίσταται τις αλλαγές της σύγχρονης. Δηλαδή, για να είμαι πιο συγκεκριμένος. Πρώτον, το παραδοσιακό συνδικαλιστικό κίνημα που αντιπροσώπευε ευρύς μάζων εργαζομένων με κοινά συμφέροντα δεν υπάρχει σήμερα. Η εργατική τάξη έχει διασπαστεί τόσο πολύ που δεν ξέρει κανένας τι να αντιπροσωπεύσει. Όταν, παραδείγματος χάρη, σε μια τράπεζα το 50% των υπαλλήλων είναι προσωρινοί ή προσφέρονται με συμβάσεις έργων, ποιο είναι το συμφέρον αυτών, πόσο κοινό είναι το συμφέρον αυτών με το συμφέρον των τραπεζιοπαλλήλων των ομογήμων. Και δεν είναι μόνο αυτό. Είναι τέτοια μεγάλη διάσπαση με τις σύγχρονες μορφές απασχόλησης που δεν μπορεί εύκολα να βρεθεί το κοινό συμφέρον. Ωστόσο, πιστεύω, μετά από την εμπειρία, υπάρχουν κάποια γενικά κοινωνικά συνδικαλιστικά συμφέροντα που θα επιτρέψουν την επανασυσπήρωση. Διότι αυτή τη στιγμή το μεγάλο πρόβλημα των συνδικάτων δεν είναι η έλλειψη μελών ή ο αριθμός μελών, που είναι η συνέπεια. Είναι ότι δεν εκφράζουν πιστικό λόγο για τους ίδιους τους εργαζόμενους. Αυτό είναι το θέμα. Ποιος ασχολείται σήμερα με τη μου επιτρέψετε να το λέω έτσι, θα το πω λίγο υπερβολικά, με το τι είπε για ΣΕ, τι είπε το τάδε σωματείο. Δεν ασχολούνται, διότι ξέρουν τα συμφέροντα του εκεί μέσα. Άρα λοιπόν πρέπει τα ίδια τα συνδικάτα να προσπαθήσουν να επαναπροσανατολίσουν τον ρόλο τους, τη στρατηγική τους, για να γίνουν ελκυστικά για τα μέλη. Εδώ βέβαια θέλω να προσθέσω το εξής. Αυτό είναι ευρωπαϊκό, δεν είναι δική μου άποψη, ότι παραδοσιακά τα συνδικάτα ήταν ταυτισμένα με τις διεκδικήσεις. Μισθή, χρόνους εργασίας, επιδόματα, ό,τι θέλετε. Σήμερα η παγκοσμιοποίηση και τα νέα προβλήματα οδηγεί έμεσα ή άμεσα, λιγότερο άμεσα, στο να τους δώσει ένα ρόλο οργανωτικό, που είναι τελείως διαφορετικό. Έρχονται και λένε δηλαδή τώρα διάφορα συστήματα, θεωρίες κλπ. Κοιτάξτε, δεν είναι μόνο πώς θα αυξήσει το μισθό, κοιτάξτε να δείτε και τα προβλήματα που έχει η σύγχρονη επιχείρηση, η αναδιοργάνωση, που θέτει η παγκοσμιοποίηση. Πρέπει να συμμετάσχετε σε αυτά. Αυτός είναι μεγάλος λόγος. Το πώς θα υλοποιηθεί με συγκυρασμό των δικαιωμάτων δεν είναι εύκολο. Αλλά πάντως είναι γεγονός ότι ο προσανατολισμός στον οργανωτικό ρόλο είναι πλέον μια γενικότερη τάση στην Ευρώπη που δεν υπάρχει για την ώρα στα βαλκανικά συνδικάτα ούτε στην Ελλάδα. Γιατί πάντα σε αυτά είμαστε πίσω, δύσπιση και κάτι εξής. Αλλά αυτό νομίζω είναι βασικό. Και συγχρόνως τα συνδικάτα πρέπει να συνέπεια αυτών που είπα, να αναμορφώσουν, αναθεωρήσουν, αναπροσαρμόσουν το περιεχόμενο των συλλογικών διαπραγματεύσεων. Δεν μπορεί η συλλογική διαπραγμάτευση να περιορίζεται μόνο στις παραδοσιακές ρυθμίσεις. Αυτές υπάρχουν και δεν υπάρχουν. Υπάρχουν πολλά άλλα θέματα που είτε συνδέονται με την τεχνολογία, είτε συνδέονται με τις ευαίσθητες σχέσεις, που σημαίνει παραχωρήσεις έναντι ανταλλαγμάτων, σημαίνει νέα αντίληψη διαπραγμάτευσης. Δεν μπορεί με την παραδοσιακή αντίληψη διαπραγμάτευσης να αποχωρήσει η συλλογική διαπραγμάτευση. Γι' αυτό και σε Ελλάδα, δεν ξέρω όλες τις άλλες βαλκανικές χώρες, οι περισσότερες ρυθμίσεις των ευαίσθητων σχέσεων έγιναν την πολιτεία χωρίς να συμμετάσχουν τα συνδικάτα. Διότι πάντα εδώ είχαμε αυτό που οδηγούσε. Μονομερείς επιλογές, χωρίς τα συνδικάτα να κερδίσουν αυτό που μπορούσαν να κερδίσουν με διαπραγμάτευση την παραχώρηση κάποιων δικαιωμάτων. Έχω την εντύπωση αυτή η μέθοδος της άρνησης διαπραγμάτευσης στο πλαίσιο της, θα έλεγα, του ακριφνού συνδικαλισμού, δεν είναι εύκολο, είναι λαθασμένη ή μάλλον δεν είναι σήμερα ιδέουσα. Δεν λέω ότι δεν πετυχαίνουν ορισμένα πράγματα, αλλά είχα την εντύπωση με μια διαπραγμάτευση, κουλτούρα διαπραγμάτευσης, θα μπορούσαν να πετύχουν περισσότερα. Και αυτό βέβαια ισχύει και για τους εργοδότες. Ότι πρέπει να κατανοήσουν, δεν μπορεί να προχωρήσει η σύγχρονη οικονομία, η σύγχρονη ανταγωνιστικότητα, χωρίς να τα βρούμε τους εργαζόμενους. Και γι' αυτό γίνεται ένα κύμα στην Ευρώπη να προωθηθεί που είχε υποβαθμιστεί ο θεσμός της συμμετοχής. Η συμμετοχή είναι μια, θα έλεγα, μεταξέλιξη της συλλογικής διαπραγμάτευσης και σήμερα φαίνεται ότι αρχίζει να αποκτά έδαφος, γιατί λένε τόσα μεγάλα προβλήματα που θέτει η τεχνολογία. Πώς θα λυθούν αυτά? Με φωνές στον δρόμο δεν γίνονται. Θέλει σοβαρούς διαπραγματεύσεις, θέλει σχέδια, θέλει προγράμματα. Είναι άλλο τελείως το πνεύμα που υπάρχει. Και αυτό πρέπει να προσέξουμε σε αυτή την ιστορία. Λοιπόν, και με αυτή την έννοια για να κλείσω, είναι ότι ο εξευρωπαϊσμός που λέμε είναι αναπόφευκτος. Διότι είναι χώρες που είναι μπροστά, αντιμετωπίζουν τα προβλήματα πιο μπροστά από εμάς. Αναπόφευκτα λοιπόν εμείς ακολουθούμε. Πάντως, όλη την ιστορία, αν δείτε, της εργατικής νομοθεσίας, ακολουθούμε την ευρωπαϊκή νομοθεσία. Συνεπώς, πρέπει να έχουμε το μάτι εκεί, να επιταχύνουμε σήμερα, βέβαια, δεν έχουμε περιθώριο την πολυτέλεια να κάνουμε μια καθυστέρηση 10-20 ετών, πρέπει να επιταχύνουμε το βήμα, και αυτό ισχύει για όλες τις ευρωπαϊκές χώρες, ώστε να δούμε πού πάει το πνεύμα, πού πάει η διαπραγμάτευση σήμερα μαζί με τα προβλήματα της ανταγωνιστικότητας, της παγκοσμιοποίησης, των νέων τεχνολογιών, ώστε να προσαρμοστούμε πιο έγκαιρα και να αντιμετωπίσουμε πιο έγκαιρα τα προβλήματα της απασχόλησης. Και κλείνω με αυτό. Είπα τα προβλήματα της απασχόλησης. Και η απασχόληση, αυτή καθεαυτή, δεν αποτελούσε αντικείμενο διαπραγμάτευσης. τα συνδικάτα πήγαιναν και λέγανε τι θέλουν για τους μισθωτούς που είναι μέλη τους, για τους εργαζόμενους. Δεν τους ενδιέφερε όλοι που ήταν εκτός αγοράς εργασίας. Σήμερα η πολιτική απασχόληση ποια είναι ουσιαστικά? Είναι μια πολιτική που λέει ότι με ενδιαφέρει ο κάθε πολίτης να έχει μια συνεχή απασχόληση. Άρα για τον πρώτη συνεχή απασχόληση πρέπει να κοιτάξω και τα δικαιώματα που έχει ο εργαζόμενος. Και προφανώς αυτό οδηγεί σε μείωση δικαιωμάτων. Αυτό δημιουργεί αντίθεση των συνδικάτων. Εδώ το μυστικό είναι ότι τη μεν πολιτική απασχόληση δεν μπορούμε να αποτρέψουμε. Ειδικά σήμερα που η ανεργία θα ανέρχεται και με την τεχνολογική εξέλιξη θα έχουμε συνεχώς ανθρώπους εκτός επιχείρησης που θα πρέπει να διασφαλίσουμε την γεννητικότητα, δεν μπορεί να υπάρχει πολιτική απασχόληση. Και δεν μπορεί ενδεχομένως, κάνω να πάρω μέρος γιατί είμαι ούτε συνδικαλιστής, είμαι απλώς θεωρητικός, ιδέες λέμε, δεν μπορεί ενδεχομένως να μην γίνει μια αναπροσαρμογή δικαιωμάτων. Η αναπροσαρμογή των δικαιωμάτων εργασίας δεν σημαίνει συρρήκνωση. Σημαίνει μια ρύθμιση που να βοηθάει και το μη απασχολούμενο να βρει απασχόληση. Δύσκολη ισορροπία, αλλά εκεί πρέπει να προσανατολιστεί. Πάντα στα δύσκολα υπάρχουν λύσεις. Δεν δίνω λύσεις, αλλά η σκέψη ότι πρέπει σήμερα δεν μπορούμε να αποφύγουμε κάτι. Το θέμα της απασχόλησης. Είναι πλέον ευρωπαϊκό θέμα γενικό. Αφού πρέπει να το φύγουμε, πρέπει να δούμε πώς θα το αντιμετωπίσουμε. Εδώ λοιπόν η συλλογική διαπραγμάτευση, νομίζω, μπορεί να παίξει στο μέλλον, να παίξει σημαντικό ρόλο και αυτό σημαίνει και μια ακόμη φορά βέβαια και μια αλλαγή κουλτούρας των συνδικάτων. Νομίζω, δεν ξέρω αν είπα αρκετά ή λίγα, αλλά έδωσα ένα περίπτωμα το θέμα.
Ευχαριστούμε τον καθηγητή τον κύριο Κουχιάδη, όχι μόνο με τις γνώσεις του, αλλά και με την εμπειρία του έδωσε το στίγμα αυτού της ημερίδας που νομίζω ότι ήταν επιτυχημένη χάρη στην συμβολή όλων των εισηγητών, των συνέδρων, του Οικουσάκουλα που βοήθησε, του Τελλογλείου, της Νομικής Σχολής Πασμού Θεσσαλονίκης και της Αθήνας. Επομένως, ευχαριστούμε όλους για τη συμμετοχή σας.